You found my name in the rain on the porch. I kept it small like a pin in a glove. Your shadow leaned on the apple crate step, and the clock in the hall would not answer us. Stay a little while, stay a little near. Your breath on my cheek like a borrowed fear. Dance me slow, paper moon lace. Hold my hand in a stranger place. Hold my hand, sweet and still we could disappear. Dance me slow and leave me here. Your collar was white, but your eyes were old, like a key in a jar with a secret hold. I heard the boards count softly our feet, and the room grew thin as a candle leaf. Stay a little while, stay a little near. Your breath on my cheek like a borrowed fear. Dance me slow, paper moon lace. Hold my hand in a stranger play. Hold my hand, sweet and still we could disappear. Dance me slow and leave me here.
Good morning, everyone. How are you? I hope everybody is doing good. Just give me one quick second. I need to move my microphone, and then we'll get started, okay? But it makes a noise, and I don't want you guys to hear that, so hold on. All right, that's better. Hi. Oh, thank you, Dana. I appreciate that. Love the new intro, Jenly. Well, thank you. I appreciate it. Now that I understand, okay, we'll have a little bit of a chit chat and then we'll get started. So with the intro, obviously I was going for a very specific aesthetic. I really, really liked the Welcome to Derry opening credits because I liked how they had, I liked the aesthetic of the postcard drawings from the like 1950s, and I liked how they mixed like wholesome images, but then there was that touch of dark in it, right? And then the song is actually that they used Patience and Prudence. If you look into those two girls, the sisters, it's interesting to like look it up just because of their ages. They were like 12 and 14 or 11 and 14 when they were first performing, and but the lyrics are very mature, and I just really liked that whole aesthetic, and I really wanted, and I also liked what they did with the camera, and how they were able to make two-dimensional flat images seem three-dimensional, and I really wanted to do that and figure out how to do it. And once it took me a while to like understand the concept, which is kind of sad for me because I took art for several years, and I understand perspective and how things that are closer to the camera are more blurred and they move faster than things that are farther away. I get all of that, but translating that into the keyframes and everything, that concept was a little difficult for me to, and then for whatever reason, like everything else in my life, it wasn't clicking, and then boom, it just clicked. So now that it's clicked, I just didn't want to take any more time and make you guys wait. And so now that it's clicked, the intro will be the same length. I'm just going to add more scenes. So there you go. Thank you for that. And Kate Can Create, thank you for becoming a member. I appreciate that so much. Thank you. All right, so let me say hi to you guys, and then we'll get started. Hey, Karen, good morning. Sharp Family Switchblade. Vanessa, good to see you. Kate Can Create. Jenny, good morning. Dana, neat. Good morning, babe. Let's see. Mally, good morning. It's good to see you. Good morning, everyone. All right, so we're going to get started with the Austin Drummond case. He has been indicted for a quadruple murder. We're going to watch some things. Hold on a second. I want to see. Hold on a minute. I want to see one thing really quickly before I hold on a second. You know what? Hold on. I just realized something. First of all, I'm on the wrong YouTube account because now we're going to have ads. Let me fix that. So, Austin Drummond was charged with murdering 4 people in rural Tennessee and abandoning a baby. So, what happened was there was a baby that was abandoned, and that kicked off this whole investigation. And then they go, and find this whole family murdered. And nope, it was Allie covered it, Alex Erickson. And so the first thing we're going to watch is his very first. I don't know if it's his very first. I don't think, but this is a preliminary hearing that happened September 6, 2025, just to get a little caught up with the legal particulars. And then we will move to what happened the latest. Okay. Vanessa, thank you for becoming a member. Welcome to the ward. I appreciate that very much. All right. And also, I'd like to apologize for not going live last night. My husband said, hey, why don't we make a nice dinner and watch The Bride? And I was like, oh, okay. And everything, you don't say no to that, right? And so, of course, and I'm just going to tell you guys, I need to watch it again. I also feel like I need to watch Scream 7 again before I feel comfortable like giving you guys a yay or a nay on it. Okay? All right, here we go. Hold on, let me turn on.
Good afternoon, everyone. Before we get started, I'm going to go over just a couple of housekeeping matters. Appreciate the folks from our law enforcement who are here today providing security for the building. Appreciate each of you, and your efforts have not gone unnoticed. I want to say that first and foremost. Second off, I want to just make aware that we are set for today for preliminary hearing in the matter of Mr. Austin Robert Drummond on the 4 counts that he had, on the 5 counts that he has before the court, the 5 cases with 2 counts each. I want to take this time just to go over with everyone. We're going to have some statements and some evidence that may be entered today that may be difficult to hear, may be upsetting to hear. If at any time you feel that you cannot sit and listen to the proceedings, I would ask that you step outside. If anyone does have to step outside, that's fine. I don't mind that. If a disruption is made, then you will be removed from the courtroom. And if further disruptions are made, the court has the right to hold you in contempt of court, or the sheriff's office has the right to issue charges for disorderly conduct. I don't want to see that happen, and I don't think that we're going to have that happen.
All right, so let me just give you guys a quick backstory, okay? So this happened back in 2025, okay? August of 2025. Are you ready? All right. A week-long manhunt is over in the killings of the parents, grandmother, and a teenage uncle of a baby found abandoned in Tennessee. Austin Robert Drummond was arrested Tuesday morning in the woods in Jackson after residents saw him. The 28-year-old is a convicted felon with alleged ties to a violent street gang who was out on bail on an attempted murder charge and dating one victim's sister, officials have said. He is due at 9 a.m. local time Tuesday in Lake County General Sessions Court for an arraignment. Still, a motive in the killings and why the baby was abandoned a county away from where the bodies were found remain a mystery. After getting out of prison last year in a robbery case, Drummond was charged with trying to kill someone while incarcerated and was out on bond, authorities have said. His criminal history dates to July 2013 when the then 16-year-old robbed a Circle K convenience store in Jackson just after midnight. He pulled out a pistol, pointed it at a store employee, and demanded the money in the cash register, court documents show. He was convicted in 2014 of aggravated robbery and sentenced to 10 years in prison. After the trial, Drummond called his father from behind bars and made threats against his jurors and the robbery victim, District Attorney Jody S. Pickens, who serves an area including Jackson, told CNN on Monday. For that, Drummond in 2015 pleaded guilty to retaliation for past action and was sentenced to 3 more years in prison, according to Pickens and court records. The DA's office opposed paroling him, calling him a, quote, dangerous felony offender in a 2020 letter. He was not paroled and was released last September from Northwest Correctional Complex in Tiptonville after 11 years, counting pretrial time and credits, according to Pickens and court records. He then faced new charges related to his time in prison, a drug arrest the day he was released, then a later one in an attempted murder case, according to records from the Tennessee Bureau of Investigation, or TBI. Quote, he made bond, end quote, and was, quote, out on bond on those charges last week when the bodies were found, said Danny Goodman, district attorney for Dyer and Lake counties, adding only the alleged attempted murder, quote, took place inside the prison. CNN has asked for more details, excuse me. Drummond's attorney in the attempted murder case, Drew Farmer, declined to give more details and would not say whether he represents Drummond in the charges related to last week's killing. The manhunt across rural Tennessee began after a baby was found July 29th in a car seat in a front yard near the Dyer County community of Tigrit, some 80 miles northeast of Memphis and 40 miles northwest of Jackson, the Dyer County Sheriff's Office said. Good morning to everybody just coming in. I just wanted to catch you guys up. Kate asks, can't believe this wasn't all over the internet, or did I miss it? It was all over the internet in the very beginning. In the very beginning, it was such a mystery because this baby, like the article reads, was just found in a car seat, abandoned. And they had to figure out who the baby was, who took the baby, who the baby belonged to. And through that investigation, that is how they discovered the family. And then we're going to keep reading. So more details are going to come out. But it did, like, the initial phases of this situation, of this case, were covered quite extensively. But they're, it's hard. And I'm to keep up because there's sadly always another case. All right. Let's see. Investigators started searching for a quote dark colored minivan or white mid-size SUV, witnesses said had left the child there. Hours later, the sheriff's office announced 4 people, later identified as the baby's relatives, had been found dead in Tiptonville in nearby Lake County. The 7-month-old is safe, authorities have said. Killed were the baby's parents. These are just young kids too. James M. Wilson, 21, and Adriana Williams, 20, along with her maternal grandmother, Courtney Rose, 38, and maternal uncle Braden Williams, 15, all were Dyer County residents, Goodman said. Drummond was wanted in connection with the death and issued warrants charging him with 4 counts of first-degree murder, 1 count of aggravated kidnapping, 4 counts of felon in possession of a firearm, and 1 count of possession of a firearm during the commission of a dangerous felony, the TBI said. Rose's sister was Drummond's girlfriend, Goodman later confirmed. The sister had been a corrections officer at Northwest Correctional Complex when Drummond was incarcerated there. CNN affiliate WHBQ reported, citing the state corrections department. Photos on social media show the pair together after Drummond was released from custody, the station reported. Quote, "We suspect the person that killed them knew all of them," end quote, Goodman told CNN last week. Quote, "I hate that someone has taken my son from all of us," end quote, Wilson's father told CNN on Sunday. "He really was a good young man. He was an exceptional father. He would help. He would stop and help anyone." Quote, "This has left a huge hole in our family," Matt Wilson said. "No amount of justice will ever be able to replace them." Investigators believe Drummond has connections to the Vice Lords gang and suspect he may have gotten help from its members, a law enforcement source said. Vice Lord members have been involved in murder, drug trafficking, and other violent crimes, the Justice Department says. The gang has members and offshoot groups in Illinois and throughout Tennessee, prosecutors said. During the manhunt for Drummond, 3 others were arrested in the case, the TBI said. Dira Sanders, 23, was taken into custody Monday on warrants charging her with accessory after the fact of first-degree murder, accused of assisting Drummond after the killings of the baby's relatives, the Bureau said. The same charges were filed last week against Tanaka Brown and Giovanni Thomas, both 29. Brown is also charged with tampering with evidence, the TBI said. Authorities have not specified what the 3 are accused of doing to help Drummond. The Bureau has not elaborated beyond its news releases, which do not tell how the 4 were killed, how the 4 were found, whether investigators know of a motive, or who may have left the baby in the yard near Tigrit. Drummond was recorded Sunday night by a residence camera system in Jackson, police there said, and a vehicle associated with him was found in the city. While Drummond was still on the run, Union University locked exterior doors to all buildings, and Jackson Christian School was put on lockdown Monday afternoon as authorities searched a wooded area in Jackson. Calls from people saying they'd seen Drummond came in around 8 a.m. local time Tuesday, and police sent more resources in that area. Another citizen's call at 8:57 a.m. led to Drummond's arrest by 3 officers at 9:05 a.m., Jackson Police Chief Tom Corley said. Today, quote, "Today we find some peace in knowing that a suspect is no longer a threat but remain committed to the families, the community, and justice," the chief said Tuesday. A couple of firearms were recovered, the TBI director David Rausch said, adding he could not say whether they were used in the killings. So that is where we are. That happened in August. So this, hang on just a second. This was, Jen, get it together, bro. What are you doing? Hold on. I'm sorry, you guys. It's still morning time and I'm not quite awake. So this is September 6th. This premiered September 26th on Court TV. That doesn't mean that was necessarily the date, just when it happened, just when it was premiered. So this is likely one of the first, if not it's the first, one of the first preliminary hearings beyond the arraignment. All right, so now we're going to get into it. So I just want to say good morning to everybody. And also I would like to say chicken noodle. I'm reading Chicken Lady and Noodle at the same time. Way to go, Jen. It's going to be one of those days, y'all, so buckle up. Chicken Lady sent me an email about the newest hearing, but I had already seen it, and then I went to go and reply to Chicken Lady, and I hit the like clicked on the email, but I thought I clicked, but I accidentally swiped, and I apparently swiped a little too fast, deleted it. Then I went to recover it, and then I got distracted by something else and forgot, and then didn't reply. So shout out to Chicken Lady. I apologize, babe, for not replying to your email. I'm a mess. I buffer. What can I say? All right, here, except for I'm very, very sorry. And I thank you for looking out for me. All of you guys that email me, I appreciate it. And keep me up to date. All right, here we go.
But I just have to give everybody that notice prior to this hearing starting. Mr. Goodman, good afternoon, sir.
Good afternoon.
General Hayes, good afternoon. Mr. Huffman, Mr. Mason, good afternoon. Mr. Drummond, good afternoon, sir. What are we proceeding on first? Because I know there is a motion before the court, and also we have a preliminary hearing. So how do we want to take that up?
We'll just do the preliminary hearing first.
Okay. Does the state have its list of who it intends to call today during the preliminary?
Yes, Your Honor.
Okay.
The state intends to call Officer Corey Hussey, Deputy Hunter Brady, Special Agent Justin Tubbs, Special Agent Scott Lawson, and Brandon Wheeler, Officer Wheeler.
Okay. Anyone else, General?
No, Your Honor, I think that's it.
Okay. Is anyone from the defense going to be called for as a witness?
No, Your Honor, we will call.
Okay. Folks, if your name has been called, and I don't know all of you who they just called out, I know some of them, but for those of you whose name was just called, you will have to step outside the courtroom while the others are testifying. Rule 615 of the Tennessee Rules of Evidence says that witnesses must be sequestered for that purpose. You cannot discuss the case with one another prior to your testimony. Who's the first witness for the state going to be?
It'll be Officer Hussey.
Okay, Officer Hussey. Everyone else who was called as a witness would step out at this time, and when we are ready for your testimony, we will have a deputy come outside to retrieve you at that time.
Yeah, our Special Agent Tubbs is our designated party.
Yes. The court will take note that Special Agent Tubbs is the prosecuting witness designated by the state of Tennessee.
Karen says, could it also be that he saved the baby because there are also reports that he was a police informant? It's all very mysterious. It's possible. And also, look, okay, so if they're in the, if they are suspecting that this had something to do with some type of gang affiliation, right? Killing children ain't looked favorably. It's not a good thing. It's puts you at even more risk, right, in prison. So perhaps that is why he spared the baby, because he doesn't. It's whatever for him. His policy is it's whatever when it comes to adults. But like he takes the Drago from Rocky IV position. If he dies, he dies. Wait, that's Rocky III. My bad. Then like with kids, that's like no dice. You know what I mean? So maybe that's what it is. All right, let's keep going.
Mr. Huffman, in general, I know y'all's normally my routine is in preliminaries. I'm happy to hear from either party on any opening, but if everybody wants to just proceed to direct examination, I'm fine either way. I just wanted to kind of get the lay of the land from y'all.
The state will waive the opening remarks. Waive opening remarks, yes.
We'll proceed then to direct examination. I do want to make sure I have officially put this on the record. We are here in the matter. I should have done that first. I apologize. We are here in the matter of State of Tennessee versus Austin Robert Drummond in cases number 25 CR 48067, 48068, 48069, and 48071. The 25 CR being those documents. Your first witness, General.
Your State of Tennessee calls Officer Corey Hussey.
Officer Hussey. If you please come to the witness stand, sir. If you would, Ms. Jessica is going to place you under oath at this time.
Raise your right hand. You solemnly swear affirm testimony you're about to give is the truth, so help you God.
Thank you, sir. And Officer Hussey, be sure if you would to speak into the microphone. We've had these things kind of messed with and fixed in a much better way, and I appreciate our IT folks for that. But just be sure to speak into the microphone clearly because we are recording. Okay? Thank you.
All right, would you state your name, please?
Corey Hussey.
And where do you work?
I'm a park ranger with Tennessee State Parks.
Hold on. Give me 1 second. I want to make sure that that didn't totally kill us here. It didn't?
Okay.
Sorry about that. Sorry, guys.
All right. Would you tell me again who you work for?
I'm a park ranger for Tennessee State Parks.
Okay. And how long have you had that position?
I took this position June 28th,
June 28th?
2025.
I'm sorry?
2025.
Okay, June 28th, 2025. Do you recall if you were working on the day of July 29th of 2025?
Yes, I was.
Okay. And as a part of your job, do you routinely patrol state parks and specifically around the Real Lake area?
Yes.
Okay. Is that something that's just part of your duties that you do that?
Yes.
How many parks are there that you have to actually patrol daily?
One park, Real Lake State Park.
Okay. Are there individual smaller parks within the whole Lake Park area?
Yes, sir. There are individual units that are all attached to Real Lake State Park.
Okay. Is there one on Carrington Road in Lake County?
So the Carrington Road location is state land managed by TWRA. However, we operate programming and tours from an area on Carrington Road.
Okay. So it's not actually a park, right?
No, sir.
Okay. It's just an area that's owned by the state and it's actually used by the state.
Yes, sir.
Is that area actually near the Northwest Correctional Complex?
Yes, sir.
Just an estimate, how far would you say it is from that area?
Maybe a mile.
Okay. And is that here in Lake County, Tennessee?
Yes,
Is that area that we're talking about on Carrington Road?
Yes, sir.
While you were patrolling that area on July 29th, 2025, did you notice anything unusual or anything that caught your attention that day?
Yes, sir.
Okay. Could you tell me what that was?
So while patrolling down Carrington Road, shortly after 1 o'clock, I found 3 vehicles parked on the left side of Carrington Road.
Okay. Do you know what type of vehicles they were?
One was a black Dodge Charger, one was a Chevrolet Traverse, and the other was a Nissan Rogue.
Okay. Did you see anyone out there, any individuals standing around the vehicles or inside the vehicles?
I did not see them.
What'd you do after you noticed the vehicles? Did you
OG Nanny says, hi, by the way. Welcome in. Good to see you. I'm not convinced he was an informant. Ellie hasn't confirmed that I've heard. Neither have I. It's just not believable because he was dating a guard. That would have been a no-no. See, I think that I don't think he was an informant either. I think that I think we're going to really have to wait until he goes to trial. Now, I want you guys to know this. One of the latest developments, right, which was at the last hearing, is that Austin Drummond wants to represent himself, and we're gonna listen to that. We're gonna hear about what the judge decided, all of those things, right? But the main, one of the important takeaways is that Austin has requested a speedy trial. So he has not waived his right to a speedy trial. So we should be seeing some movement fairly quickly coming up in this case, as far as we should be going to trial pretty quickly.
Did you stop, get out, did you do anything?
I proceeded past the vehicles when I was making entry down Carrington Road. Then I turned around and proceeded back out from that location.
Okay. As you came back out of the location, were all the vehicles still there?
No, sir.
Which vehicle was no longer there?
The Nissan Rogue had left in the time it took me to turn around.
Okay. Did you notice anything about the Nissan Rogue that was unusual for this area?
It had a California tag.
I'm going to hand you this photograph. You would look at that photograph. Do you recognize either one of those 2 vehicles in that photograph?
The Nissan Rogue with the California tag would be the similar make and model as what I saw.
Okay. Is that vehicle similar to the one that you saw there that day?
Yes.
When you turned around and came back, was the vehicle leaving at that point, or was it already gone?
It had already left.
Could you tell anything about if it was left hurriedly, or could you tell?
In the time it took me to turn around, it had already left from where I could see it. There's quite a bit of dust in the air. As I proceeded out on Carrington Road, there are several straightaways, and at no point in time did I see the vehicle. So it indicated it left in a hurry.
Would you make that photograph with an exhibit to your testimony, please? Judge Pickle.
Yeah, I'm sorry. Mr. Huffman, have no objection? Okay. The court will show that this be entered as State's Exhibit Number 1.
Officer Hussey, after you saw that vehicle leave and the other two vehicles that were still there, did you see anyone around at that point, around the vehicles?
No, I did not see it.
Okay. Did you make a report about that?
I wrote notes to myself, but I did not file any report at that time.
Okay. Did you later tell someone about that?
Yes, sir.
And who was that?
My manager, Doug Roberts.
What made you tell him about that incident?
Later that evening, he messaged me that there had been an incident on Carrington Road.
Okay. And at that point, what did you tell him?
I immediately called him and informed him that I had been there earlier that day and had seen those vehicles.
Okay. And was that information passed on to local law enforcement?
Yes, sir. I shortly received a call from the Sheriff's Department along with PBI and shared that knowledge with them also.
And after that, did you produce all of your findings to a report?
Yes, sir.
Yes, sir.
You stated that when you first saw the vehicles on Carrington Road, that you drove past them and then turned around.
Yes, sir.
How long did it take you to go down to the area that you were turning around and then get back to where the vehicle was?
Only a few minutes, less than 5 minutes, probably 2 to 3 minutes.
2 to 3 minutes? Okay. Did you notice anything about the vehicles? Were any of the doors open or anything like that?
When I was coming past the vehicle the first time, the black Dodge Charger's trunk was open.
What about when you came back?
The trunk had been closed at that time.
So you passed 3 vehicles, the trunk is up. Within 2 to 3 minutes, you come back, the trunk is closed, and the Nissan Rogue is gone.
Yes, sir.
And when you get back to the road, you see no sign.
Yes, sir.
All right, now I'll pass witness.
Yes, sir. Mr. Huffman?
Briefly.
Yes, sir.
Officer Hussey, were you able to see any individuals on scene? So you drove past and you noticed any individuals?
No, sir.
Okay. So when you drove back by, same thing?
No individuals at that time.
Custody?
Yes, sir. Can you redirect, General?
No, John.
Officer Hussey, we thank you for being here, sir. You're released from your subpoena. You can have a seat here, or you're free to go, whichever you'd like to do, sir. Thank you very much. Next.
Statement called Deputy Hunter Brady.
Yes, sir. Deputy Brady. Yes. Absolutely. Deputy Brady, if you would, please raise your right hand.
You solemnly swear for our testimony you're about to give the truth so help you God?
Have a seat, sir.
Good afternoon.
Name.
Would you state your name, please?
Hunter Brady,
And Deputy Brady, where do you work?
Lake County Sheriff's Department.
And how long have you been working there?
Been here a little, almost a year now.
Okay. Do you remember if you were working on July 29th of 2025?
I was.
Okay. And was that an early day or was that in the evening?
We've been in the evening.
Okay. Was that the shift you typically work?
That's correct.
Had you received any information earlier in the day about a baby being abandoned in another county?
I have not.
Okay. Had you heard anything about that?
Just on social, what I've seen on social media.
Okay. But you had seen that earlier that
Yeah.
day? Okay. Did you know at that time who the parents of the baby was that was dropped off or anything about that?
No, I did not.
Did you receive a call later in that evening that vehicles that may have belonged to the baby's family had been located?
I did.
And who did you get that call from?
One of the family members of, I believe one of the victims involved.
Okay. Did they call you directly or did they call dispatch?
They called our dispatch.
And you were dispatched to that area?
That's correct.
Where did you go? Where was the area that you responded to?
Carrington Road.
Is Carrington Road in Lake County?
It is.
Once you got to Carrington Road, what did you do?
So when I first got there, we spoke with the female caller. She advised that she found her family vehicle was parked back on the dead end road, which is halfway down. And I made my way down there and located the white Chevy Traverse and the Dodge Charger.
Was anybody else with you, any other officers?
Yeah, there's a Tiptonville officer, Officer Morrow, and Deputy Karen Gross.
Okay. Did y'all all arrive at about the same time?
Yeah, they were probably a minute behind me.
Okay. All right, so you proceed down Carrington Road, you find a black Charger, Dodge Charger, and a white Chevrolet Traverse vehicle. All right, okay. Was anyone in the vehicles?
No, the vehicles were vacant.
Did you run any registration on the vehicles to see who they belong to?
And I was approaching the vehicle when Deputy Gross started running the registration on the black Charger.
Okay. Were you able to determine who that black Charger belonged to?
No, not at the time.
Or at a later time?
At a later time.
Do you know who that was? Do you know if it was Braden Williams?
I never received the information from dispatch. She's the one that ran the registration.
Okay. All right, fair enough. So you didn't see anyone in the vehicles at the time. Did you start to look around the vehicles or look in the vehicles?
Yeah, so I first looked in the passenger side of the vehicle
Which one?
of the white Chevy first.
Okay. Did you notice anything when you looked inside?
Yeah, red substance that I believe it was blood at the time, all in the passenger side front and the passenger side rear.
Okay. What'd you do at that point?
Advised the other officers on scene that we had either an active situation going on or something had happened and we needed to search the area.
Okay. And so did you start to do that?
Yeah.
Okay. Tell me what happened.
I walked around the vehicle a little bit and then I noticed a shoe sitting off the trail that was directly behind the vehicle and it had some blood on it, so that was the direction we determined we needed to go. And I went off in the woods and that's when I located 2 bodies in the directly behind the white Chevy Traverse on it.
Okay. Did you, before you found the bodies, did you notice if there were any shell casing around the vehicles or anything like
No,
that?
not at the time. Not yet.
Okay. Did you later find that
Yes,
there were?
yes. After we located 2 bodies, we started taping everything off and made our way back up. And that's when we located multiple shell casings around vehicles.
Okay. All right. Let's go back to the first 2 bodies that you located. Tell me how they were when you found them.
The male was laying on his back under his mother, and there was a tarp over the top of him.
Okay. What was the tarp? Do you know what it's made of? Or
It was like the camo nylon material, the mesh material.
were both bodies completely covered with that material?
Yeah, except for they had maybe their hand exposed out inside.
But what'd you do at that point?
That's when, started communicating with the officers, hey, we needed to secure the scene, start a crime log, and then look for and gather evidence.
Okay. Did you secure the scene at that time?
Yes.
What did you do to secure the scene?
We taped it off, cleared the area, and, contacted our supervisors so they can contact DBI.
Okay. All right. After finding those 2 bodies, were there ever any other bodies discovered?
Yes.
Okay, tell me about that.
It was after Dyer County arrived. One of the Dyer County deputies noticed a shoe on the south side of the road, and I was standing with him, and I noticed some red pools, what appeared to be blood, and then we just kind of shined in the woods, and you could see 2 more bodies under tarps.
Okay. Now, was this in the same area as the original 2 that you found?
No, this would have been south of them, across the gravel roadway. It was in the same area, but it was,
But how close were they to one another? Before you had the 2 initial bodies and then 2 others. How far apart were
probably
they?
like 60 feet.
But, were those bodies covered as well?
They were.
Same type material?
Same type of material tarp.
Okay. Were you able to identify who any of them were at that time?
No, not at that time.
Did you have any other involvement with this case?
I did not.
Yes, sir.
That's the witness.
Yes, sir. Mr. Huffman?
Few questions. Deputy Brady, okay, so you were dispatching this area, Carrington Road, is that correct?
That's correct.
You remember about what time that would be?
It was roughly 8 o'clock, I believe.
Okay. Are there dispatch logs, recording times?
Yeah, that's right.
When you arrived on scene, you said there was one Tiptonville officer and another officer on scene?
Lake County Sheriff's Deputy. Yes, sir.
Okay. When you arrived on scene and you noticed these things, you said that you secured the scene after you discovered the body, is that correct?
That's correct.
The first set of bodies?
Yes, sir.
All right. How many total officers were on scene at that point in time?
When we found the first set of bodies, there was just 3. We know 4 because a trooper had showed up right as we were entering the woods.
And you recall which officers those were?
Trooper Hayden.
And did you write any reports or anything like that?
I did.
Were those things be located in that report as well?
Yes.
All right. You said when you were on scene, you secured the scene by taping it off?
That's correct.
All right. And how long after arriving on scene and discovering bodies did you do that?
It was within minutes.
All right. And contact your supervisors and they contact your TBI, is that correct?
That's correct.
Were you wearing your body worn camera at that time?
I was.
Was it active at that time?
Yes.
Is that footage backed up?
Yes.
And available for discovery?
Yeah.
Were you in a marked vehicle?
I was.
Does that have a dash cam?
It does not.
The other officers, do you know if they had body cams or dash cams?
They have body cams. We don't have dash cams.
To your knowledge, were those active as well?
To my knowledge, yes.
And when you were securing the scene, were you doing any evidence collection?
We was marking evidence as we were finding it, yeah.
Okay. Did you remove any items?
No,
Did you take any photos at that time?
I did not know.
Yes, sir. Any ready, Director General?
No, Your Honor.
Deputy Brady, thank you, sir. You're releasing your subpoena. You are either free to go or free to stay, whichever you'd like to do. Your next witness, General.
I'm going to call Officer Brandon Wheeler.
Officer Wheeler. Officer Wheeler, please come to the witness stand, sir.
Well, good morning, Jonah's mom and Jonah and Pointer Lover and Kelly and who else has joined us? Adrian, Brandy. Good to see all of you guys. Thank you so much for being here. So brief, and thank you, Pointer Lover, for being a member for 29 months. I appreciate that so very much. This happened back in July of 2025. Okay. They, get this call about this abandoned baby in a car seat. So they start, doing investigations. It leads back to a home that's got 4 family members that are dead in it. All the babies, the baby's parents, the baby's grandmother, and the baby's uncle on the mother. All the other relatives, the grandmother and the uncle, are on the mother's side. And so they look at camera footage from neighbors from the area. They discover this vehicle. They start, then the manhunt begins. Okay. And so there's been some movement in this case very recently, and as it pertains to the trial. So I thought what we should do is go back and listen to the initial preliminary hearing. He's been charged with aggravated kidnapping, first-degree murder, a ton of stuff. And so, and he has requested a speedy trial. So that means it's, they have a finite amount of time between the charging and the trying. So let me just check on that and make sure that it doesn't say waived the right to a speedy trial, because I feel like I read it, but I don't, for whatever reason, it's not sticking in my brain and I don't want to misspeak. So here we go. We're just going to watch a little bit more of this. I don't want to overwhelm you guys because I know everybody really wants to get to the newest hearing. So I can do that too. I'll just listen to a little bit more of this if you guys want, or if you want to stay and we can do a whole big deep dive, which is what I really planned. I just wasn't sure how you guys were feeling about it. All right, here we go.
And if you would, sir, please raise your right hand.
Do you solemnly swear for testimony you're about to give the truth, so help you God?
I swear. Thank you, sir. Be sure to speak in the mic.
Well, welcome in, Karen. I am new to your channel. I'm from Australia. Welcome. Thank you. The baby is okay. Yes. Yes, Jonah's mom. The baby is okay. Yeah, the baby survived. That's how, that's why he's charged with aggravated kidnapping and not the murder. All right. Welcome in, Karen. It's very good to see you. Welcome to the ward.
Please state your name. Detective Brandon Wheeler. And Detective Wheeler, where do you work?
I work at the Dagford Police Department.
And were you involved in this investigation to the case of why we're here today?
Yes.
Okay. What were you asked to do?
I'm not sure if Special Agent Harbor reached out to us or if we reached out offering assistance, but we were trying to identify a vehicle that was of interest.
Okay. And how are you trying to do that?
So we have 2 LPR systems. There's a Motorola LPR system and the flock camera system, and we were utilizing those to try to identify a rogue, Nissan Rogue.
What is the LPR?
License plate reader.
And was there anything in particular about the Nissan Rogue that you were looking for?
Yeah, this one in question specifically had a California plate on it, which is not typical for our area.
Okay. And City of Dyersburg had these 2 license plate readers, right?
There's more than 2, but there are several in the city.
Those systems?
Yes.
Block and Motorola?
Yes,
And you have the ability to access those, right?
I do.
And can you access any other ones?
We can access other cameras that other agencies have shared with us.
Okay. And did you do that as part of this investigation?
Yes.
Who else did you access?
There's several thousand agencies that openly share their cameras with us, so we can search all of them all at once.
Okay. And aside from Dyersburg, who else did you end up searching as it relates to this investigation?
The Jackson cameras.
Okay. I'm going to hand you up some photographs. Do you recognize that one?
I do.
Okay. And what is it?
It's a picture of the silver Nissan Rogue with the California plate.
All right. And what system did that come from? Block or Motorola?
This is from the Flock system.
And is that in Jackson or Dyersburg?
Jackson.
And what time is that?
11:32 a.m. on the 29th of July.
And do you make that an exhibit to your testimony today?
Yes.
No, we have to make that statement exhibit to.
No objection.
No objection.
Okay, that's, we'll mark this on State Exhibit 2, Ms. Jessica. Thank you.
Okay, so just really quickly, I want to explain some of the things that Austin Drummond has requested. Hold on, I'm going to cough. All right. So these are very recent. This is written May 26th, 2026. All right. He has motioned for a speedy trial. This request is for the court to expedite all proceedings in his case. A speedy trial is the constitutional and statutory right of an individual to be brought before the court within a quote-unquote speedy time or be released. Drummond says his need for a speedy trial, quote, comes from concern of lost evidence and diminished memories of witnesses. Motion for order to set deadline to disclose discovery. This motion is to order a deadline for the district attorney to disclose discovery eligible to the defendant. The reason for the order, as stated in the motion, is to allow the defendant adequate time to review the discovery and to prepare his defense, as well as protect his constitutional right to a speedy trial. Motion for copy of preliminary hearing transcript. This motion requests the preliminary hearing transcript and copies of evidence exhibits presented in the preliminary hearing. This information is needed so that the defendant can use it in, quote, pretrial motions and trial preparation. Motion for additional discovery requests that the district attorney general, any law enforcement officer, or any person acting in conjunction with a law enforcement officer, allow Drummond to inspect photocopies of any books, papers, documents, or tangible objects obtained from Drummond and related to his case. He specifically requests any written statement, confession, or admission made against him, reports or results of scientific tests or experiments made within the case, all diagrams, photographs, video or audio recordings, and or moving pictures, all books, papers, documents, or tangible objects planned to be evidence, inventory of all telephonic, radio, and or recorded information in connection to the case, all data and information to be extracted from cell phone companies, and cell phone towers, all social media data, including posts, photos, messages, videos, calls, and location data, all materials which are exculpatory in nature, the names and addresses of all persons who participated in the investigation, records of tips called in. Drummond also requests to be informed of if any statements have been made to any agent of the state or other person acting on behalf of the state that has not already been known. He has a motion to quash or, in the alternative, for an in-camera review. This motion was not requested by Drummond, but rather the Department of Children's Services. This order requests to, quote, quash the subpoenas for production of documentary evidence issued to the Department of Children's Services, or in the alternative, for an order requiring an in-camera review followed by a protective order as set out. DCS wishes to make all reports of child abuse confidential to protect the victim. So that's important because we're obviously dealing with the minor here. So, and also one of the other reasons I wanted us to watch this is because, um, um, you know, a lot of us, most of us have followed the Summer Wells case. We have followed Sebastian Rogers case, and there's been a lot of discussion surrounding the TBI, surrounding local law enforcement in Tennessee, and a lot of, I think people get frustrated with law enforcement agencies in general because they see it as a lack of communication, a lack of transparency. But the truth of the matter is, they have to protect the integrity of the case for when it gets to trial. This, because they're a branch of law enforcement, is a branch of the justice system, the judicial system. Okay, they're an extension of that. So the goal is to bring justice to the victim or victims, and they work together with the courts, and they must protect the integrity of the case. I know it's frustrating. I get frustrated too. I want to know what happened, but I also know that we need to wait to protect a potential trial, and that's important. So here we go. I just wanted us to have like an idea of how it works.
And Officer Wheeler, do you recognize what's also been handed up to you now?
I do.
And, please. You recognize that one as well?
I do.
Also, I wanted to highlight what Kelly wrote because I think this is also true. Kelly says he wants to get back to the lap of luxury of his prison cell with PlayStations, pizza delivery, endless supplies of liquor and snacks. Right, that's why he wants a speedy trial. I mean, we've seen this before. Look at Lori Daybell, right? She complained endlessly about the conditions in the county jail where she was being held awaiting trial in Arizona. And we learned over the years that for many people, for many defendants that have already been in the prison system before, right, they know that prison provides better accommodations than the county jails. And that's what they want. They want back there. So.
Hey, what is it?
It is a picture from the Motorola system in Dyersburg, capturing the vehicle going northbound on Highway 78.
And that's the same road with the California license plate?
It is.
It's the same license plate as we saw in the first picture?
It is.
Okay. And what time of day is that one captured?
This one was captured at 12:39 p.m. on July 20th.
And where is that one located? Where is that particular camera located at in Dyersburg?
That particular camera is located at the intersection of Lake Road and Radio Road, right in front of Love's.
Okay.
Could you repeat that again, where it was, intersection of where?
Yeah, Lake Road and Radio Road.
Radio Road, okay, I'm sorry.
Between Love's and Cracker Barrel.
And do you make that one good for your testimony as well?
I do.
Okay.
Show this marked as State's Exhibit 3.
And then let's go back to the second picture that actually handed up to you. You recognize that one as well?
I do.
Okay. And is it from the same camera that you just identified as the last picture?
It is from the same set of cameras facing a different direction.
Okay, which direction does that camera face?
This one is facing southbound towards the city.
All right. And what does it depict?
It shows a picture of the same Nissan Rogue California plate heading back in towards Dyersburg.
And what's the date and time on that?
This picture was taken at 2:15 p.m. on July 29th.
2025.
Correct.
You make that one exhibit to your testimony as well?
I do.
You know, we'd have to make that exhibit for.
Okay. Absolutely. Show this marked as State's Exhibit number 4.
One more photo.
Yes, sir.
Do you recognize that one as well?
I do.
And what system did it come from?
This is from the Flock system.
Is that in Jackson or Dyersburg?
Jackson.
And what date and time captures that one?
This picture was taken at 4:16 p.m. July 29th, 2025.
And does it depict the same road as we've seen in the previous ones?
Yes, same road, same license plate.
Do you make that exhibit to your testimony as well?
I do.
And we'd have to make that State Exhibit 5. No objection.
Show this marked as State's Exhibit number 5.
You can have that passed back to Officer Reader.
Officer Wheeler, on that last photo, was there anything of significance that you noticed?
Yes, this is a photo taken from the front angle of the vehicle, and you can see the driver in this photo.
Okay. And can you describe the driver?
The driver appears to be a white male, has a goatee, and looks very similar to the defendant.
And was there anything that you noticed about the vehicle in that photograph?
Yes, so the vehicle in this photograph appears to be much dirtier, especially around the wheels and the rims, than it was previously earlier in the day.
Your Honor, passing it.
Yes, sir. Mr. Huffman?
First few questions. Detective Wheeler, so you were asked to look for a Nissan Rogue with California plates, is that correct?
I don't remember the exact parameters, but I believe we were looking for a Rogue with California plates.
Do you have a plate number?
No, sir.
Once you located the vehicle in the photos that was presented in the evidence, did you continue looking for other Nissan Rogues with California tags?
Yes.
Did you find any more?
No.
And the only photo, I believe, was Exhibit 5 with the front view of the vehicles. There are other ones from the rear, is that correct?
I don't remember exactly, but I think they were all from the rear.
And then the one on Exhibit 5, which is from the front.
Yes.
That's all.
Any redirect, John? No, Your Honor. Detective Wheeler, thank you, sir. Appreciate it. You're free to go, free to stay, whichever you choose to do, sir. Your next witness, General.
Special Agent Scott Lawson.
Agent Lawson. Agent Lawson, if you please come to the witness stand, sir. And before you have a seat, if you would, sir, please raise your right hand.
Do you solemnly swear affirm testimony you're about to give is the truth and nothing but the truth?
I do. Thanks.
Sorry, you guys. My husband set up the other monitor for me again, and now I have to fix it because I need to make it where it mirrors, and I keep losing the mouse pointer, so I have to like search it over. It's driving me nuts. I got to get used to it again. Jonah's mom would like everyone to know that she has chocolate chip cookies to share. They are sugar-free, yet they do not taste sugar-free. Neat Noodle has been in top chat this whole entire time. Make sure that y'all are not in top chat, that you're in the live chat. All right. I want us to see how they put this investigation together. That's important. Okay. And it will give us a preview for what we can expect moving forward in the trial. And I'm hopeful that the trial, should it get there, will be streamed because I'd like to cover it.
Sir. Yes, sir.
State your name.
My name is Scott Lawson.
And do you work for the Federal Bureau of Investigation?
I do.
Okay, what is your current assignment with the FBI?
I'm a special agent on the Safe Streets Task Force.
Okay. And were you involved in the investigation as to this homicide in Lake County?
I was.
What role did you play?
Most of my experience is in the command post assisting with cell phone analysis from tolls, working with timelines and video review to assist in the exploitation of cell phone data.
Okay. And have you received training on cell phone data?
I have.
What kind of training have you received?
I'm a member of the FBI's child abduction team, and we get yearly training with our cellular analysis survey team. That's the experts at FBI headquarters with analyzing cell phone data, geolocation data. So when we deploy with the child rapid deployment team, we are consistently working in partnership with the CAS team to analyze cell phone data and kind of feed each other back and forth to further investigations.
Okay. And is that what you did here?
Yes, sir.
Okay. What specific cell phone data did you look at?
We started off our investigation by doing a deep analysis on the tolls of the victims' cellular telephones. When I say tolls, I'm speaking of the incoming and outgoing calls from the victims' phones to include records of incoming and outgoing text messages.
Okay. And when you did that, did you notice anything in particular?
Yes, we worked off a theory due to many of the victims arriving at the scene where they were murdered at at various times, right? So they didn't all just appear there together. So we worked under the theory that someone must have organized a meeting or at least some type of reason to get the 4 victims to the crime scene. So as we were looking at the victims' tolls, we were looking for any unknown or unusual cell phone activity, particularly any cell phone number that would have contacted any of the victims consistent with maybe asking them to come to this location.
Okay. And did a number stand out?
There was one number that was immediately interesting. It showed up on the cell phone analysis at approximately 6:38 that morning, 6:38 a.m. That number was unknown as far as the tolls that we had analyzed to that point of known numbers of associates of the victims. In addition, another thing that we do when we're working these investigations is try to determine when the victims' phones stop taking calls, right? We're trying to work on a timeline. We're trying to narrow everything down so that our cell phone data is strong as possible. We noticed from the 4 victims' phones that none of the victims answered a call or made a call after 7:01 a.m. So knowing where they were located and when their phones stopped answering calls, we knew that whatever had happened to them had most likely happened right around or just before 7:01 a.m.
And the number that stood out, was that 731-345-7426?
It was.
So prior to 6:38 that morning, there wasn't on any toll of the victims.
Right. We subpoenaed the number and ascertained that that phone had just came on for the first time ever that morning, and that it had been purchased the night before at a Walmart in Dyersburg, Tennessee.
Okay. And so what else did you do next?
We asked for tolls for that cell phone number to ascertain who, at that time, we could only see when it had called one of the victims' phones, which we had their tolls. So we now asked for the tolls of the number ending in 7426. One of the first things we saw when those tolls came in is that at 7:01 was the last call with one of the victims, Adriana Williams, and at 7:25 it was calling persons associated with the rental of the Nissan Rogue car that was in question. So we knew pretty confidently that number was very interesting to us. We then asked for the cell phone company to provide geolocation records for the cell phone 731-345-7426, and immediately we ascertained that that number had been at the crime scene and had started traveling south from the crime scene at approximately 7:24 a.m. As I mentioned earlier, my job is to combine the phone, the video reviews, and the timelines to make it tell a story, to help it assist in telling a story. We also had ascertained that Matt Wilson's vehicle was also going south from the crime scene, passing a camera at approximately 7:25 a.m., and the cell phone data put this newly identified cell phone number passing that same camera at a time consistent with Matt Wilson's truck going southbound.
And Mr. Wilson's truck is a late 80s F-150?
That's correct.
Can I ask one thing? I'm sorry. When you say passes the camera, are you referring to the camera that, where was that camera?
I should have been more specific. Yes, sir. So
I apologize.
No, absolutely. There was a fire station on Highway 78 just north of the main intersection here, headed towards the crime scene, and that was the video that caught the F-150 traveling southbound at 7:25 a.m.
There had been some testimony about cameras, and I was trying to make sense of which one was talking about, so
Yes, sir.
I apologize for interrupting the agent. Yes, sir.
All right, Agent Lawson, you had mentioned that 7426 called a number associated with the rental. Can you explain that?
Yes, due to some good work performed previously, there was a Nissan Rogue that had been identified that had been rented in Jackson, Tennessee the day before and picked up on the morning of the homicide. This vehicle was captured on license plate readers going northbound towards the crime scene and then going southbound away from the crime scene at a time later in the afternoon. In addition, there was some identification of the vehicle from a park ranger being seen at the location. The investigative team followed up with the rental agreement and with Enterprise Rental Car to learn about the who had rented this vehicle, and identified a Michelle Ovelis, I may not pronounce the last name correctly, Ovelis, as being the renter. As that investigation continued, she had identified that the vehicle had been given to Austin Drummond and rented on Austin Drummond's behalf.
Okay. And did she have any connection to the defendant, Mr. Drummond?
Her boyfriend, Giovante Thomas, was closely associated with Austin, and she was also closely associated with an individual named Tanaka Brown. Our phone toll analysis identified that at 7:25, as that number 731-345-7426 was leaving the crime scene, it was jumping on a three-way conference call with Tanaka Brown and Giovante Thomas.
Okay. And then what happened next?
So obviously at this point, we were extremely interested in just learning everything we can about the user of this telephone number. We learned that upon departing the crime scene, it traveled to an area in Dyersburg commonly known as Bikini Bottoms. Bikini Bottoms used to be like an off-road recreation vehicle area for ATVs and such. When the phone arrived, and a point of interest, as this phone is traveling south towards Bikini Bottom, one of the victim's phones is traveling in concert with that phone, so that was very interesting to us as well. Both of those phones got to the Bikini Bottom area, and the phone 731-345-7426 arrived at Bikini Bottom at approximately 7:44 a.m. and stayed in the area to approximately 9:04 a.m. Based on what we do with violent crime investigations and the knowledge base that we have, we theorize that something, as far as getting rid of evidence or weapons or something had happened at that Bikini Bottom area.
And in fact, did it?
It did. There was, based on the phone data and the investigation in whole, search parties were organized to go to Bikini Bottom. On the day that these phone tolls were being worked, they initially found a Tennessee driver's license for Matthew Wilson. And the next day, we found Mr. Wilson's vehicle down the ravine there at Bikini Bottom.
And that's the late 80s F-150 truck?
Yes, sir.
Okay, so as you can see, yeah, I'm having, look, y'all know I love SpongeBob. I can't help it. I will, you know, it is what it is. My kids watched it growing up. Now my grandbaby is watching it. So at the continual mention of the location Bikini Bottom is giving me a little bit of the giggles. I'm going to be mature. I'm not going to giggle like audibly. I'm just going to keep it to myself. I'm going to mute because I don't want to be rude and I don't want to be offensive to anybody because this is a serious case. It's just the term Bikini Bottom. I'm having a little struggle. Okay. I just think it's interesting how they have how the investigation went. And remember, there are the people that he was just talking about. They're facing charges as well for aiding and abetting. I mean, that's not what their charges are. They're accessories after the fact, and that's what they are being charged with. Brandy says her husband still watches it too. Okay, I'm not going to ask your husband's age. I'm too old to be still watching. I don't watch SpongeBob independently. Okay, the only time I watch SpongeBob is with my grandbaby now, but yeah, I do like SpongeBob.
Did 7426 stay at Bikini Bottom?
It stayed there till about 9:04 a.m. and then it began a southeastwardly travel towards Jackson, Tennessee.
Okay. And did it eventually reach Jackson?
It did.
Do you know what time?
I'll refer to my notes for a more specific time. We saw it arriving in the Jackson, Tennessee area at approximately 10:04 a.m.
And where did the phone go while it was in back?
The phone first travels to...
I'll rewind this back. I just wanted to let you know, Dana, I put my email in the chat for you, babe. All right, let's just go back just a second.
The phone first travels to an area consistent with the Clarion Hotel in Jackson, Tennessee. It then moves towards the Cherry Grove Apartments, and then eventually back up towards Dyersburg.
Okay. Let's stay in Jackson for a minute. Was there any significance to the Clarion Hotel?
Through the investigation, the Clarion was identified as a place where Austin Drummond resided regularly and potentially used as a place to organize criminal activity.
And what's his vehicle at the Clarion?
The information from the investigation is that his personal vehicle, the Audi, was at the Clarion. Mr. Tanaka Brown, who picked him up at Bikini Bottom, drove him back to his vehicle at the Clarion, and then followed him to Cherry Grove to depart, to leave the Audi sedan.
Okay. Was there any significance to the Cherry Grove Apartments?
Cherry Grove Apartments is where Mr. Drummond's girlfriend, Caitlin Speed, resided. The investigation revealed that when his vehicle was departed at the Cherry Grove apartment complex, that he ascertained some cleaning style brushes at the apartment.
And then you said after that it starts moving back north toward Dyersburg?
There's a little time with it still being in Jackson, but by 11:55 a.m., the phone began a northwestern travel towards Bell, Tennessee.
And then it reached Dyersburg?
We have the phone in conjunction with the license plate readers being in Dyersburg at 12:39 p.m. and by 1:04 p.m. being back north of Tiptonville near the crime scene.
Brandy says he watches independently. It's actually very annoying. He says it helps him disconnect. Okay, I'm just going to say this. There is research that there is when people watch things that they've like over and over, like they have their familiars. For me, when I have a lot on my mind and when I need to disconnect, right? A lot of times I will go back and watch like the old beginning episodes from like the Real Housewives series, like their first seasons. That's one place I go. And recently I used to be an avid watcher, like I never missed an episode. Once I found it. There's this show called The Dead Files. And it's paranormal. It's about paranormal activity or whatever, but it's really good. And I found it again. And so lately when I've like, which I know seems weird, like how can you go from true crime and you use that to disconnect? But it's actually like, I don't know, I find it interesting. And for some reason, it's comforting. And they say that that is something people do when they need to disconnect. They will go back and watch things. They have like their comfort shows when they need to get out of their head, when they need to not think. And I do it. So I am not fixing to judge a nobody. But yeah.
And did it stay at the crime scene very long?
The phone appeared to stay, and just one note of reference for an education and this geolocation stuff with phones. You get these records either when a phone call is placed, a text message is placed, or some type of data transfer between the phone and the network. So if Instagram sends you a notification or your bank pops up and says you overdrafted, like any kind of data transfer, you'll get a location data. But a person could be at a place a couple minutes before and we would not see that due to if there was no data transmission, could stay at a place a couple minutes after. These time frames are based on a call being made or a data transfer happening. So the last data transfer we saw near the crime scene was at 1:14 p.m.
All right, and then what happened?
1:38, we started seeing timing advanced data southbound from the crime scene.
Timing advanced data.
Timing advanced data is how a cellular tower communicates with the handheld phone device. So in a nutshell, the cell phone towers that you see have 3 sectors that cover a 360-degree circle. Each of these sectors cover approximately 120 degrees. When the phone is on the network, it's constantly sending some type of signal to the phone to determine how far away it is from that network. And the primary reason is a business sense from the phone company. They need to know which tower that phone should be using to have the strongest reception or the strongest data capability. So as that ping is going to that phone and coming back to that tower, if it's getting a little too far away or maybe a little closer to another tower, it'll tell it to start communicating with the stronger tower. So what we can do in law enforcement is we can ask to obtain that timing advanced data. And what that will do is say when the phone was making that call or having that data transaction, what sector is it on, what 120 degree arc from the tower, and how long did it take that communication to go to the phone and back. So if you have 120 degrees and you're measuring the time from the tower to the phone and back, you're able to say that phone is somewhere in that arc that represents the amount of time from the tower and back.
So 1:38, you start seeing timing advanced data moving south from the crime scene?
That's correct.
And what happened next?
Still tracking south towards Dyersburg through 2:14 p.m. Then we have another license plate reader hit in Dyersburg at 2:15 p.m. From the next timing advanced data of significance was from 2:32 to 2:35. It was tracking towards Friendship where the 8-month-old Wesleyan was dropped off. The phone hit a arc right over the house where the baby was dropped off at approximately 2:35 p.m.
When you say the phone hit a arc, what does that mean?
So when the phone made either a data transfer or a phone call or a text message at 2:35, the phone communicated with the tower in an amount of time consistent that it had to be in an arc that covered the area of the home where the baby was dropped off.
Okay. So then what happened after that?
Around 2:35 to 2:55, the phone starts slowly going back northbound towards Dyersburg. We learned through our investigation by 3:11 p.m. that a 911 call was coming in about the child being in the yard. From 2:57 to 3:23, the phone starts tracking towards Bells, Tennessee, southeast again, eventually towards Jackson.
Okay. And does it eventually reach Jackson?
It does. At 3:39 p.m., the telephone number was back in the Jackson, Tennessee area. Of great significance to the investigative team. At 4:22 p.m., I'll try to explain this. It's a little bit difficult, but I mentioned the arcs where a phone can be in. So if you've got a sector pointing this way and you have the arc, but if you're in a city and you got multiple towers close, sometimes you'll see the arc from this tower and then the other tower facing back at you, you'll see its arc. So if you ever have two arcs intercept, you can not only say the phone is in the arc, you can say it's exactly, you can say with great confidence that the phone is where the two arcs intercept. You almost have to see that, but where the two arcs from two towers intersected from 4:22 p.m. to 6:06 p.m. was right over Austin Drummond's parents' home.
Then did he leave his parents' home?
Approximately 6:34, we saw the phone being in an area consistent with the Clarion Hotel again, and then at 8:44 p.m. we saw the phone being in an area consistent with being back at Cherry Grove Apartments at Kate Speed's residence. And then of note, the phone went off the network. Well, let me mention this. Of note, that, Lake County received a 911 call at 8:17 p.m., kind of alerting the family and the public to what's going on. The phone went off the network for the last time ever at 8:44 p.m. So the phone was just turned on for that day and then was never used again after 8:44 p.m.
Thank you, Agent Lawson.
Yes.
Mr. Hoffman?
Good question, Agent Lawson.
Yes, sir.
So your role in this case was essentially limited to the cell phone data analysis, correct?
Cell phone analysis and just assisting with interpretation in the command post of the timeline, the video, and the phone data.
Okay. All right, now, I actually understand what you're talking about with the triangulation regarding those things. The only way, so when you have cell phone data, my understanding is, and also from your testimony, there are 120-degree arcs. You typically, cell towers have three areas, encompassing 360 degrees, is that correct?
That is correct.
Right. Now, in order to determine the position of the cell phone, you can tell which sector it's in, correct?
Absolutely, yes, sir.
And unless you have the timing advance data, you do not have a distance from the tower, correct?
Right, that requires the timing advance data.
All right, so if you do not have the timing advance data, you just know it's somewhere in that sector.
Yes.
And that could be large area, square miles, correct?
Yes, sir.
All right. How many of these locations did you have timing advance data? For instance, you said there's one where the timing advance data gave you triangulation directly over Austin Drummond's parents' house.
Yes.
All right. A couple times you testified that you had the cell phone at the crime scene.
Yes.
Was that given with the timing advance data, or was that just in the general area with the sector?
That was with timing advance data, but it would be with one arc, so it could be in a great length of area in an arc, but the arc was over the crime scene.
Okay, so you did have a sector and an arc.
Yes.
Oh, that was my question. Did you ever determine who purchased that cell phone? You said it was purchased in Walmart in Dyersburg. Is there any evidence who purchased that phone?
We believe that two of the victims purchased the phone the night before.
Do you have any evidence that Austin Drummond purchased that phone?
Not him personally, no, sir.
In King Bottom, you said that you located the Tennessee license of Matthew Wilson as well as the truck in a ravine, is that correct?
The truck was in a ravine. My understanding is the Tennessee DL was a paper copy, and it was not down the hill. It was up more in a kind of common area, but it wasn't down the ravine.
Were you involved in that search or processing that scene?
No, sir. No, sir. Yes, sir. Any redirect, General?
No, Your Honor.
All right. So basically, they connected him to all of this through camera footage and phone data. Now we're going to switch over. We're going to listen to the latest. I can't even think. The latest. What's wrong with me? The latest hearing. Okay. Let me turn the volume up. Let me make it full screen. Oh, wait, hold on. No, I don't want to do that just yet. Okay. All right, let me take this off the screen. There we go. Now I can do it. And also, I would like to thank Sweet Jonah for gifting a Ward Case Studies membership. Lady Wags got it. Congratulations to you. Oh, really, Chicken Lady? Chicken Lady and I are having a sidebar. And we're talking about the Dead Files. And I asked about Matt. Matt is the guy it's actually Amy Allen's ex-husband. They were a couple at one point. She's remarried. He's the one that used to go with her on her walks at the locations and film her. So I would like, I'm curious. I didn't even know that they had replaced her. That's such a bummer. All right. So now we're going to watch the latest. On Austin Drummond. Let me just look at this really quick. Hold on, let me see something. Let me tell you when this happened, because I've already, my brain is just buffering today. Hold on. Give me just a sec. This happened. Let me see. A couple of weeks ago in mid-May. So I'm way behind on this, but I just wanted to give you guys that. All right, so here we go. Oh, it'd be helpful if I showed it on the stream. Hold on. Let me close this. Now, this is on Facebook. So if any of you guys have me on Facebook Messenger, even though I've turned off all my notifications, please don't message me right now. All right, here we go. I wonder.
Let's make sure we have our sound and we're able to make a good record this morning. There. Mr. Huffman, probably, once we get to it, probably need to be at the podium just to make sure we're doing well. Let's get Mr. Swift, 25 CR 11205, Jesse Swift.
Judge, we have the discovery, we have an offer, we have a revised offer that I need you for.
Just really quickly, I see Austin has switched his hairdo now. He's going, I guess, grown it out and trying to do, I don't know, it looks like the Justin Bieber swoop to me, but whatever. Just such a dirtbag. All right, here we go.
We get one more report date on this case, but we should be officially resolved it or set the next day.
About one of our maybe our June, May's pretty quick and pretty busy as well. What's our how about June 22, Mr. Huffman? Mr. Swift, that work for you as well, sir?
Yes, sir. Will that be 1 o'clock?
1.
Well, now, how about that? They done scheduled to something about another hearing for June 22nd. So Jonah's mom, looks like you gonna get your wish. I'll be streaming on June 22nd. I would have anyway, but this is what we're going to be covering. So Katie Katz asks, what's this about? So this is about the quadruple murder suspect. He's been charged with 4 murders and aggravated kidnapping. This happened in Tennessee back in July of 2025. It started out with a report of an abandoned infant. The baby was in a car seat on somebody's lawn. And the investigation led back to a home where 4 people were murdered. And so 2 of the people that were murdered were the baby's parents. These are all young people. Well, they were 21. The mother's brother and the mother's mother. So now we're up to Austin Drummond is the suspect. He's the one that has been charged. We are up to the latest preliminary hearing. This took place. I want to tell you it was like May 15th is when this happened, 15th or 16th, and 2026. He is going to request to represent himself. So and he's also requested a speedy trial. So that's where we're at now. This is not the first hearing. I just finished the very first preliminary hearing, where basically what we went over in that hearing, I didn't play all of it. But basically we learned how they connected Austin Drummond to the homicides and the kidnapping of the baby, as well as 4 other people who were also charged with accessory after the fact, through cell phones, cell phone location, call logs, and also like cameras around the city, also cameras in the neighborhood. So, hey, Becky P, good to see you. Yeah, he does look like a giant dweeb. All right, let me push play for you guys. All right, here we go.
Okay, great.
Hold on, before I do this, let me mess around with the settings and see if I can get us better. See if I can add closed captions. Hold on a second. Oh, let me see what else they let you do. I can speed it up. That's nice. So let's speed it up to 1.25. I've got the audio all the way up. I wish I could make it with closed captions, but I cannot. Let me just check up here. No. All right. Let me put it back on the screen for you guys.
We'll either set or dispose that day, okay?
Yes.
Very good, thank you. Let's go ahead and, I didn't know Mr. Drummond was in the courtroom. State versus Austin Drummond, 25 CR 11185. Have a number of matters to take up. I want to at least start. I don't think we'll finish it, but I at least want to start. Mr. Drummond, with your motion to waive your right to counsel, pardon me, and exercise your right to self-representation. The court's read your motion. There are a number of things we need to do before the court can consider your motion. I'm going to hand down to you a document that is called Waiver of the Right to be Represented by Counsel. It's essentially a questionnaire. You're being asked to answer a number of questions. It's an 8-page document. And then there is once you get to the end of it, there is a page for you to sign in writing that you desire to waive your right to counsel in this matter.
Kate can create. I can't find any information on the motive. Okay. I don't know what the motive was on this. I suspect law enforcement and the prosecution does know or has a theory of the motive. Okay. And I suspect that will be obviously presented in trial. I think that they're holding that part close to the vest.
There. Hand it to Mr. Huffman and Mr. Ferguson first. Let them look at it and make sure that what I'm saying is correct, and then they can hand it to you, Mr. Drummond. Do you have a pen, sir? You're gonna need an ink pen. That's mine.
Yeah, don't be the judge is like, that's mine. You're not going to take my ink pen. The first motion before the court on this date is Austin Drummond waiving his right to counsel. He wants to represent himself.
There you go. So what I want you to do, take your time, read through that, answer the questions if you will, and then we'll come back to that in a few minutes, okay? While you're looking through it, if you have any questions, we'll stop the other matters we're doing and I'll answer your questions as best I can, okay? There are other motions pending, and today was a motion hearing date. The motion, also before we get started, there are a number of motions which have been filed by Mr. Drummond pro se. court's not able to take those motions up today simply because motions that were going to be heard today were required to be filed before. Prior, there was a deadline, I think was May 1, for motion filings for motions that will be heard today.
Thank you, Katie Katz, for gifting a star. I appreciate that. Thank you so much. I appreciate that. Thank you.
I anticipate we'll set another motion date with a motion deadline for both sides and see where we are. In the case.
And the gold coin.
Like
Thank
this,
you.
There are generally 2 or 3 motion hearing
Appreciate that.
days before we're able to get to setting that for trial.
So Kelly says he wants to represent himself and he shows up without a pen. He's already off to a great start. For reals. How you gonna be up there pro se, ain't got no pen? Oh, that's right, because you're locked up, can't even bring a pen.
You'll need a minute to go through that before you hand it off to Mr. Drummond.
Yes,
Oh, thank you, Katie Katz. I appreciate that. Katie Katz says,
I've revised the
I always
questionnaire a
enjoy
little
your content. Thank
bit
you.
in light of the Court of Criminal Appeals decision just a couple of weeks ago, actually 1 week ago, May 4, in State versus Christopher Fiedler, that Henry County case that the Court of Criminal Appeals decided that modified the procedure just a little bit for pro se representation. You want a copy of the questionnaire? No, sir, I do not. I brought one actually, and then didn't give it to you.
Wants to represent himself. Wonder when he made this decision, because so in when like the judge mentioned, in preliminary hearings there are deadlines for filings. So, I guess he decided to represent himself, who knows when, but he filed the motions requesting to represent himself, plus on top of other motions, too late, past the deadline. So the judge is like, I'm not going to take those up today. We're going to deal with these other matters. And I thought he's supposed to be reading this pamphlet about representing himself and filling out a questionnaire. Ain't doing nothing. He's just sitting there. What are you doing, Drummond? Oh, he's waiting for his attorneys, I guess, to look over it. I'm so confused. I thought he was supposed to be looking over this questionnaire and filling it out. I'm curious as to, I wonder if I can find the motions.
we do have one.
Uh-oh.
Question of choice is you will have to select a jury because it's a capital case. We suggest changing that question to a capital qualified jury.
I'm happy for you to write it in, and that's a fair.
So that question was about jury selection. They need to get basically, the death penalty's on the table as a punishment. So they need to get a death penalty qualified jury. That takes time.
Okay, further since handed off questionnaire to Mr. Drummond. Let's look at the motions that are scheduled.
All right, so Katie Katz says, Jen, can't believe Letitia Stout is getting a new trial. Sorry, off subject. Well, look, it is on subject because we're talking about trials. We're covering true crime, so it's on subject. We're all shocked and appalled that Letitia Stout is getting a new trial. It appears like The Island and Lost, that 2023 ain't done with us yet, is not finished with us. So we're going back to 2023 because not only is Stout getting a new trial, but Murdaugh is getting a new trial as well. And I think that it's very, very important. And I must mention this, and please take this mention in all caps, bold font, underlined. Okay. both Alec Murdaugh and Latisha being granted new trials based on jury issues. None of their direct appeals as far as the evidence of guilt goes was how do I phrase this? Those appeals were denied. Okay? So both of them are getting retrials not based on any evidence of innocence or any error committed by the state during the trial. They are getting new trials on a technicality related to the jury. I will say this. As irritated and annoyed as I am, that's both these people are getting new trials because they're expensive. It has to do with the jury and not actual none of the actual evidence against them. But in the United States of America, this is our system. You are afforded the right to a fair trial to be decided by the jury, a jury of your peers. That is one of the fundamental foundations of our justice process and the justice system. So if I said, oh, this is ridiculous, they shouldn't get new trials, I wouldn't really be supporting our justice system, because that is part of the situation, and that's part of our process. So it's important that the jury be fair and impartial. What I'm curious about with Latisha is I know the state is going to present basically the same evidence, right? The evidence is the evidence, and none of that was thrown out. But what is she going to do?
Today, the first one I've got is the state's motion for protective order for discovery, which was previously granted by the court. There's been a motion filed, Mr. Huffman. I think you filed a motion to modify the protective order. Is that right?
That's correct, Judge.
Karen says he wants access to all the evidence. Letitia Stout did that too, if I remember correctly. Yes.
Do you have a proposal as to how that would work?
So what Letitia did is she filed a motion to represent herself, to go pro se. After evaluations, back and forthing, hang on just 1 second. After all of that, the judge said, okay. So he granted her request to represent herself. She did. We learned through the phone calls from El Paso County Jail, which are on my channel and Alex Erickson's channel. They're in playlists that include the calls that were played on both channels in the in the playlists. So we learned through that that after she got her pause on the evidence and was starting to go through it, all of a sudden, remember she had that incident where she was, according to her, sleepwalking, fell off the top bunk, hit her head, and lost a whole year. Remember that? Right. And then that's when she then changed her plea from not guilty to not guilty by reason of insanity. She's a snake. All right, here we go.
Right now, Mr. Drummond does not get to keep a copy of the discovery because of the history of publicizing. Creates a lot of problems for the case. Number one, it creates a lot of unnecessary publicity. It is difficult for the families of the victims, and it's really interfering with the orderly process in this case. So how do you propose we modify that in order to not have a problem?
Well, Your Honor, I think I've actually got the second motion, which is to review the statutory requirements to have him be remanded back to a local jail. They kind of go hand in hand. The biggest issue that we have right now is being
Okay, I forgot to mention this because this is big. This is important. This is an important detail. Initially, after his arrest, Drummond was held in the county jail. Okay. But then he started acting a fool and getting in trouble. So they moved him from the county jail to the prison. Okay. And now this is an issue. Okay. Because when a defendant is representing themselves, they get the discovery. The discovery includes sensitive, personal, identifying information of everybody, of the witnesses, I should say. I shouldn't say everybody, but he has, we learned earlier, we wants to know the names and the addresses and phone numbers of all the witnesses and the investigators. And the thing about that is, and it would make anybody uncomfortable, he killed 4 people. Okay. And then after he allegedly murdered 4 people, he had help from other people to keep him, cleaning up, getting rid of evidence, hiding him out. If I were law enforcement, would I be nervous for myself? Probably not, because I'm law enforcement, right? I'm trained. But you know who I would be nervous for? My family. And it's a problem. And also, in his other cases, in one of his cases, he made threats to the jury and to the prosecution. If I remember from that article, so he has been, he's not above threatening people involved in the case. And to threaten juries is ridiculous. Look, bro, let me just explain something. They don't want to be there. People try all manner of things to get out of serving on jury. Okay? So they don't want to be there. Don't blame the jury. It's ridiculous. It's disgusting. Let's keep going.
Effectively communicate and coordinate with Mr. Drummond. Where you think house now is extremely difficult to be able to even give him copies of discovery to review while we're there. Miss Ferguson here, an investigator, has been there a couple times, and the issue that we have is the way TOC is allowing the in-person visitation is it's conducted through glass, and it's very difficult, and we've got it controlled.
Is she going to testify any differently from her affidavit?
I don't think so, Judge.
You've seen the affidavit? Yes. I've seen the affidavit as well.
Yes. So that's presenting a big challenge. We are able to meet by Zoom, and we can do screen shares. But as far as being able to really have meaningful opportunity to review that discovery, it's not feasible, especially with the Zoom timelines and the way we have to coordinate with staff.
What is it about the Zoom that prevents you from speaking with him?
Well, the Zooms are going to be limited in nature because they have to have a staff member, although not in the room, right outside of the room, as opposed to in the visitation area. And so we're limited in scope and length when it comes to visiting by Zoom. We are able to communicate with them, but it's in short bursts. Again, we can show him with screen shares, but that's going to be a very limited time frame for him to review the documents. And of course, he can't retain them to review them at any length. So that's bringing a very big, significant challenge, especially with the 6-minute right, to.
And you think that would be fixed if you had better access to him? Is that what you're telling me?
Absolutely.
Even if he doesn't get to retain copies of the discovery?
Yes, it would obviously be more advantageous if he could retain copies of the discovery. My suggestion to the board would be to have some kind of a modification of that order where the documents are available to them in the prison, but they would still need to be controlled from the standpoint of not being able to take it back to the cell. For instance, he could go to the law library and check out the materials and review it when he's able to have right time or whatever, but just not being able to take it back maybe to the cell.
Is that available where it's presently housed? It's not, probably not available in a local jail.
I'm not certain, Judge.
All right. Now we had this issue with Boone 10-10-7-7 when she was representing herself. Okay. Because jails have laws. Jails have laws. Prisons and jails, they do. Laws, rules. Tomato, tomato. right? And, you know, they're only allowed to keep but so much in their jails or in their cells, because obviously the more paperwork, it creates a fire and safety hazard, all of the things. And so they're trying to make accommodations for him to be able to, he has a Sixth Amendment right to be able to defend himself in his proceedings. He is afforded the right to assist in his own defense. And they're having issues apparently because of his where he's being housed. But at the end of the day, hey, Austin, this is part of it is on you, bro. You acted a fool while you were in the jail and they moved you. It is what it is. Behave, idiot.
I think that there is a law library where he's at, but again, that would be subject to the prison staff being able to get in there to be able to do that. It's just not feasible for him to be able to review. It's voluminous discovery plus videos, and it's a lot of discovery.
You understand what I'm looking for is some reasonable assurance that the materials are not going to also wind up in some sort of published form.
Absolutely.
Publicly published.
And I think that if there's some potential resolution crafted where those materials are controlled, but available for him to take out during the day or whatever, but again, not take them back to his cell or whatever. As long as the staff make sure that they control access to those documents, and if they don't go back with him, I think that would be the better alternative. That's the only other suggestion that I could have that would allow him to review his discovery in a meaningful manner, a lengthy manner, because again, it's a lot of documents.
I understand that. I understand that. Say one more.
Yes, briefly. Our position really depends on what is available for him at Riverbend or wherever he's housed. Obviously, the state files a protective order, so requesting a protective order, and we want it to remain in place, but our concern is just like the courts, the availability of it to be published. So whatever possibilities there are at Riverbend that Mr. Huffman has talked about, whatever those are, that's kind of when the state would really know its position, what's publicly or what's available that staff can do to allow him to see his discovery, but also to make sure this does not make it out on the internet.
Well, we don't know that. I'd a whole lot prefer to know that information in order to make a decision on the motion to modify. But it may well be worth looking into where we could put it on a checkout basis if the Department of Correction Law Library at whatever facility he may be at, he is able and available.
Judge, I have some good contacts with General Counsel through the Department of Corrections. I don't mind starting an email chain with him and Mr. Huffman and Mr. Ferguson, and maybe we can find out what avenues they potentially have, and then we can present those to the board at a later time.
I'm not trying to cut you off from putting the investigator on, however, she's going to testify consistently with her affidavit.
That's what she testified to, Judge. I read the court.
And I don't want to cut you out of the opportunity to cross-examine. Yes, sir. Well, I'll tell you what I'd really like to hear before you do that. What I'd really like to hear is that we're past that. We're past the need to publish stuff, the desire to put stuff out in the public that continues to interfere with this case. That's what I'd like to hear. I hadn't heard it yet. What I'd like to hear. So what do you need to tell me, sir? He's going to need a microphone. We can get him on the record. Just keep your seat right where you are. What do you need to tell me about that issue, sir?
Your Honor, I just want you to know that I have no intention of publishing any documents that will be given to me to review.
You understand the history is inconsistent with that, right?
Speaking directly about the court, that's not released.
We don't need to talk about it. I'm just worried about what we do in the future. What's done is done. Let's talk about what we do in the future. And if you're telling me you're past that, it helps me.
Yes, Your Honor, I have no intention of publishing.
You understand that if the court modifies a protective order and something winds up being published out there, number one, I'm going to find out about it. There are too many people following this matter. I'm going to find out about it. And number two, it's going to really cause you a problem. It's going to delay getting your case tried, which means you're sitting in prison doing nothing. Okay, you understand how that, additionally, and based on history, some of this stuff isn't helpful to you. You know? Okay?
Yes. Your Honor.
But thank you for telling me that. Anything else you need to tell me about it?
Yes, just a suggestion. If there's any way to give the order that I be furnished with some type of device or equipment to where I can review the documents digitally, I wouldn't be taking copies. There'll be no concern with that.
Okay. Thank you for asking me. It's a fair question. Yes, sir. Please do.
the state's concern with that is, he's saying today that he will comply with the order.
Right.
You ordered him on one location not to violate a gag order, not to release any information on discovery, and he's continued to violate your order. As a matter of fact, he has done that twice since he's been at River Bend and has been written up twice for violating the orders of the court. So the fact that he says he will not do that does not give us much comfort, because he said that before and has violated these same orders before.
Well, I'd rather be hearing that than be hearing I'm going to do what I want to do. No, sir, I'm going to let your lawyer respond. Right now, you're represented by a lawyer. And I appreciate what you told me, but your lawyer is responsible for this part of this matter, sir. Any response?
Judge, I understand the history of the case. Obviously, the motions are highly charged here. And given the history, I understand why the court has concern and issued the gag order as well as protective order. But that being said, we really need to be able to communicate with him effectively, and he really needs to have a meaningful opportunity to review the discovery and participate in its defense and work with us. How that has to happen, I understand the court's concern with him being out there. Mr. Drummond made a good suggestion. It's, because the documents we have are digital. We can give them paper copies. We can give the prison paper copies, but we can just as easily give them digital copies as well.
I'm not sure whether I have the authority to order the Department of Correction to provide certain equipment.
No, I'm not suggesting that. I was saying that if that is a potential, I think that will go a long way to alleviating the court's concerns. It's a lot easier to control a digital tablet or whatever than it is, thousands of documents, which is the alternative that we have.
I see what you're saying.
Yes.
What I think I'd like to do, General, is to, if you will, make your contact with the Department of Correction with the idea if an electronic device could be provided to a librarian or other person that's available for him to go and look at, in a meaningful way, and that's the whole idea here.
Yes, and I think that's
meaningful review.
What we need to figure out is what are the facilities' capabilities.
You're right. If we know that. Now, we'll be back here on the 26th on some other matters. There, but maybe, I don't know if you've got, if that's, didn't give you a lot of time, does it?
We're not going to get on the 26th, Mr. Hayes and I, so perfect day.
You all have mentioned that already.
Yes.
Yeah, I'm sorry, I didn't think of that. Okay, so we're going to hold the motion until we have additional information about that. I don't know if you can do that before then, so we can at least be thinking about how we deal with it.
I'll send an email.
Does that include a motion about moving to a local jail?
No, I'm going to deal with that separately. There's a defendant's motion for discovery and inspection. Are there any issues about discovery at the moment other than the problem with meaningful review?
Karen asks, can she receive the death penalty in the new trial? Okay. Technically, because of when she was charged, let me look at that really quick. Hold on. I just want to make sure on dates. Okay. Colorado officially abolished the death penalty on March 23rd, 2020, when Governor Jared Polis signed Senate Bill 20-100 into law. The repeal prospectively ended capital punishments for all offenses charged on or after July 1st of 2020. Letitia was charged with her crime March 17th of 2020, which would make her eligible technically for the death penalty. However, then she would get these automatic appeals, blah, blah, blah. And likely what would end up happening is that her sentence would be commuted to life. So there's no real advantage for the state to seek the death penalty in Letitia's case, because it likely would get she would likely get it converted to life without the possibility of parole, and it's expensive, right? So if you charge somebody with an offense and you seek the death penalty, the state seeks the death penalty, then they have to go and get what's called a death penalty qualified jury, which is that means that they have to send out more summonses. They have to cast basically a wider net. The process of jury selection is longer, thus being more expensive to the state. And if it's just not advantageous to the state to, for them to charge her, when her sentence would likely get commuted to life without the possibility of parole. In theory, yes, technically that can happen. However, practically, I don't think that would ever occur. So yeah. Yeah, I have normal keyboard tapping today, not pounding on the keyboard and being frustrated. All right, here we go.
No, sir. I mean, we've been working with Bill Hayes on this, and as he's getting these documents, he's getting to us in the final matter. We have a lot of discovery already. There may be additional things coming in, of course, as basically it's an ongoing investigation. So there may be additional documents that are coming in, but Bill Hayes has been very diligent in getting those to us. Right. So there's no other discovery issues that I'm aware of at this time.
You agree?
I do want to say to you guys, ATS News had a fantastic live last night. Let me put her channel in the Nightbot. I think this is how I had it. Sometimes I don't remember. I made the commands and I don't even remember what they are because I rely so heavy on Neat. There it is. She had a fantastic live last night about all of the things CrimeCon that's been going on, the live streams from CrimeCon, all the shenanigans. It was so good. Go check Amber's ATS News' channel out. She does great work, great true crime, great all the things. I just adore her. And I suggested yesterday that Amber and I go. I can wait because I wanted to go to CrimeCon for forever, but I don't want anybody to go with. And she's not in the season of her life where she can because she's got littles and they need her. So I said I would wait for it to be her season and then we could just go and just people watch. All right, here we go.
There's several pending lab reports still from my lab that we're waiting on. A lot of reports that we've done by that work.
There's a defendant's motion for sculptural material under Brady versus Maryland. Are there any disagreements at this moment about what might constitute Brady material?
No, sir. In fact, I filed that motion initially with
I know. The defendant filed a motion for the production of witness statements related to direct testimony. Looks like the state does not oppose that. Am I right about that?
Yes, sir.
Even though Rule 16, Sub 2 does not require it, the state does not oppose that, Mr. Huffman. If you would like to draft an order which would grant that by consent.
Yes, sir.
Motion for records of conviction. And as I understand, the state does not oppose providing a copy of the records of Mr. Drummond, of his prior convictions, but it is opposed as to witnesses. Is that a fair way to summarize your position?
Yes, sir.
Is there any, Mr. Huffman, is there any authority for me to order the state to provide you with conviction records for witnesses?
Judge, not until they take a stand, then of course that becomes relevant for cross-examination. It's just a motion to see that information early, just to prevent any kind of delay in trial.
What do you say about that?
But even once they take a stand, I don't think that changes the state's duty. Rule 16 does not mandate it. And as I pointed out in our response, the state's not required to seek the evidence when it's equally available. It's public records, they have as much access to it as we do, so I don't think if anything that just because somebody takes a stand, we didn't have to turn over a conviction.
What you're talking about usually applies to witness statements, which would be available after their testimony. However, the state is going to provide those ahead of trial rather than after a witness has testified. I don't think the state is obligated to provide a defendant with copies of arrest records or conviction records of state witnesses.
I agree. The only, okay, the defense is asking for any criminal records pertaining to witnesses. And I'm not sure that, I'm not an attorney, so I don't know. I've not ever heard of this happening before, not for every witness. Obviously, yes, there would be specific witnesses that would testify that their criminal record, particularly if it has to do with anything relative to dishonesty, right? That would come into question, and that would be useful to the defense to impeach their testimony, put their credibility into question, all of those things. The only other list that the defense is entitled to with respect to the state witness list is the Brady list. And that would be any of the state witnesses, and this pertains to employees of the state, like law enforcement officers, crime lab technicians, crime scene investigators, that kind of thing, who medical examiners, who have a track record of, or not a track record, if they have anything on their employment record where they violated admonitions for violating policy and protocol, dishonesty, and the like. So, yeah. They are entitled to that, but they're not entitled to a background check on every dadgum witness.
So the motion is going to be granted by consent as to the defendant, but denied as to state witnesses. Mr. Hayes, will you prepare one? Defendants filed a motion for hearing on prior convictions and bad acts. The state does not oppose the motion. Court is going to grant the motion and comply with the procedure set out in the Rules of Evidence 4034 and 608, 609. We'll look at all of that jury out as it presents itself. Okay?
Yes.
Prepare an order or something?
Yes.
Defendants filed a motion for permission to file additional motions. That is unopposed. The court will set a hearing schedule with a motion filing deadline each time. I'm not going to cut you off until everybody feels reasonably confident that they've exhausted the pretrial motions that need to be filed.
Yes, that was
Right. I agree. I just wanted to address it, and I would like an order. I would like an order down on it so that it's clear. The court's taking it up. Defendants filed a motion to suppress statements, and I understand that that's probably just a preliminary filing to protect the issue.
Yes, sir.
At this time, are there any statements of the defendant that need to be heard and considered by the court under this motion?
Not at this time, Judge. I will discuss that with Joe Hayes. I don't anticipate that being an issue, but there may be something.
I understand. I just can't rule on a statement that I don't have.
Yes.
That's the thing. What's the best way to leave that? Deferred?
Well, the only issue is it's not specific, so they would need to file another motion to do a statement or.
Well, they could amend this motion to say, okay, now we've got this statement of this date that needs to be addressed.
And that's what I anticipated.
Okay.
It popped up. We followed it.
Yeah. Let's do an order, Mr. Huffman, deferring the motion to suppress statements. defendants filed a motion to reveal any agreements with state witnesses. The state does not oppose it. And my notes indicate that there are no agreements that have been revealed or to be revealed. I assume the state, if you don't oppose the motion, would reveal any agreements made with state witnesses. So let's have an order, Mr. Huffman, showing that motion is granted.
ATS News says, I'm sure Southerners hate my Yankee slang. In fact, I've gotten comments asking me to say y'all instead of you guys. Speaking as a Southerner, I don't hate your Yankee slang. I find accents and phrases and sayings fascinating across the board, no matter where you're from. I would never ask you to switch to y'all. We try for that, OG Nanny. Sorry. All right. This is important now. They filed a motion for change of venue. OG Nanny says I'm usually a rewatch, but love the chat here. No drama. Yeah, we try to keep it drama free over here. Like the crimes we cover are dramatic enough. We don't need extra.
In this case, the state does not oppose the motion. Court intends to grant the motion. No alternate venue has been selected. I'm open to suggestions about that with the underlying why this would be the place to do it. I think that for this particular case, Dyer County, as the other county in this district, is probably not the appropriate place to try to conduct the trial. So I think we've got to go a little bit farther out there. As you know, we're commencing trial. Mr. Drummond has another case that's going to be tried July 23 and 24 in Carroll County. We'll find out pretty quick there whether and when. And that may prevent us from being there for this particular matter.
Does the court wish to be heard on
I'll say this, if they stream that trial, hopefully they do, I will absolutely stream it, because this is the case that this is the attempted murder charge that he was out on bond for when he committed these crimes. So I definitely, I'm kind of, if they do stream it, I'll watch. I kind of think they won't, because they're going to try to, this is the most serious case. It's a capital punishment case, and they're not trying to taint the jury pool. They're already granting a change of venue, all the things. So I don't know. We'll see how it goes. I hope they do.
that issue today, or do you want additional
I'd be obliged just to get a brief statement, memorandum, letter, don't care what it is, from both sides about what an appropriate venue would
Yes, I've already looked at a lot of those, and there are several counties that would be suited for this. I didn't know before.
I don't mean to be smart, but if you'll tell me directly.
Oh, yes, sir.
So we don't have to see it on the news,
Absolutely.
Where you want to go.
I will send you a memorandum.
Okay. That's we know that.
The state has a suggestion already out.
Has a suggestion?
You will hear that.
Yeah, I'm here. Yeah. The government doesn't hear.
The state feels that Dixon County would be an appropriate place to have this. The reason we say that is it gets over towards Middle Tennessee. Hopefully, there's been media coverage here, but hopefully not as much. Plus, there's my understanding they also have a courtroom that's always available there, and an extra courtroom. So as far as scheduling is concerned, it will be easier for us to schedule the trial. That's the reason that we would suggest that.
My concern is the Memphis media market and Jackson media market.
And that's what I was going to say, Judge. Gibson County Courthouse is, I did it multiple times, tried jury trials, not even well close to
Where's that?
It's going to be.
Where are you talking?
Gibson County?
Dixon County.
Oh, you said Gibson.
Dixon.
Oh, okay. That changes it, good.
Thank you.
I like that. Gibson County's not going to work. But we would suggest probably something closer to East Tennessee. Anything that gets us out of the Shelby County, Jackson area with the extensive media coverage, and looking at the population to pull the death qualified veneer from, you're going to need a significant population to be able to get through a lot of those things. And so the four primary counties I was looking at were Knox, Hamilton, Shelby, and Davidson, with the understanding that Shelby County is the largest county in Tennessee, so we've got a significant veneer to select from. But the concern with that one would be media coverage on that. So the top four that we would be suggesting would be Knox, Hamilton, Shelby, and Davidson.
Have you considered Murfreesboro?
That would also be within that realm.
Sir, it's within what I've considered and thought about.
Yes.
It's almost like considered again, because I don't know.
Right.
But I have thought about Murfreesboro.
Yes. And state's not opposed to any of those with the exception of Shelby County. We do object to Shelby County just because of the media. There's been so much coverage on this that we're concerned about the potential jury.
And I understand.
Your first and sure would make travel easier for you, wouldn't it?
Well, yes, it sure would. I try to run cases sometimes, most of the cases are in Shelby County, and they're usually 2 or 3 years, 2 years after the facts. Like the guy who ran around all over Memphis killing and shooting people all day and closed the city down. By the time it came around to pick a jury, nobody remembered it. Memphis has a really short memory of crime because they have so much. I hate to say that in a file, but we would still be able to effectively pick a jury from there if we had to. It would just be an issue of people concerned with two folks. But
Would there be a courtroom available?
oh yes, we're going to get 2 new judges. I'm sure that there are plenty of judges there who'd love to take a holiday and let you have a courtroom. There's also courtrooms in other buildings down there. We could use one of the circuit court buildings, which would be set up to have a jury trial across the street. But we would not have any trouble getting somebody down there to let us use it for us. So,
And the jury veneer is almost always,
it's also
a jury veneer there is almost always available.
it's always available, and because of our jury commissioner, they're very good about it. They bring in 300 every Monday. What they do, or what we do, is we actually go and get our own separate veneer, bring them in a week or 2 early. If we're doing questionnaires, bring them in about a month early, and then those people would be sequestered off the normal 300 at $50. So we wouldn't be competing with any other trials.
Okay. All right, thank you for the information, I appreciate it. You finished with that, Ms. Drummond? Do you have any questions about it? Would you all pass that back up to the commander? Thank you. Thank you, just a minute. There's been a request for speedy trial filed on behalf of the defendant as well. The court will set the matter for trial at the first available opportunity to do so. Cases of this kind they move at a slower pace than anybody thinks they're going to. They demand an inordinate amount of time in order to get ready for the actual trial, and given the fact that we're going to be moving to a different county, is going to be subject to scheduling and whatever venue we wind up. But it's the court's intention to set this matter at the first available opportunity we can, and the court is going to be very aggressive about enforcing deadlines that are imposed so that we can get this case tried. The interest of the defendant, the public, the victims in this matter, their families are to reach a conclusion at the first opportunity we can. That's what I intend to do. Sir?
I have a question on the second.
Well, we're not there yet. I want to come back to you first. There was a motion filed to enforce statutory review requirements and to remand the defendant to the custody of the local jail. Let's go ahead and take that matter up right now. There, Mr. Tubman, I think it's your motion, sir.
Yes, sir. So back before Mr. Drummond was sent to PDOC, the court had a hearing on the requirements on what, if the local jail was insufficient to detain Mr. Drummond. The court made an order, and that's why he's in okay now. However, the statute requires the court to review that every 30 days to determine if that it's still the same thing. Any local county jail is insufficient to house Mr. Drummond pending trial. He's obviously a pre-trial detainee. It should be normal course of business would be to have him housed in a local county jail. And of course,
right, but that ship has sailed, and so I'm happy to do the statutorily required review.
Well, the court is required to look at that to determine if there is still insufficient local jails, and the court only heard, of course, it was not my case, it was in the other department's case. The court only heard from O'Brien in Lake County and I think Dyer County. But there's a whole bunch of other local jails in West Tennessee that would be more than sufficient. And the court needs to hear what the state has done to look at defining a sufficient jail, not an inconvenient jail. It might be inconvenient for a jail to house them, but of course, you take judicial notice that they house dangerous criminals all the time, and contraband gets in all the time. The court needs to look at whether or not there is a sufficient jail in anywhere in West Tennessee, not just TDOC, and not just Slade, not just Fire. You know, you got going down 51, you got Lauderdale, Tipton, Shelby County, 201, I would say Hollis is very dangerous criminals.
Look, it's not about just the dangerousness of the criminal being housed, right? It's all people who are dangerous criminals get housed in county jails awaiting trial all the time. That's not the issue here. Okay, it's not his level of dangerousness. It is his behavior while being in the county jails. I'll tell you why he was moved. Okay. So back in January of 2026, the Tennessee Court of Criminal Appeals in Jackson has denied Austin Drummond's latest appeal on a previous judge's decision to transfer him to a state prison while he awaits trial. The appeals court upheld previous ruling made in November, according to documents filed January 12th, noting that Drummond's move to the Tennessee Department of Corrections would have, quote, absolutely no effect or bearing on the presumption of innocence. Let me see why he was moved. Drummond was initially held in Obion County because the Lake County Sheriff had determined that his jail was insufficient to safely keep him due to the lack of a maximum security area and means to separate him from other inmates. Judge Mark Hayes decided in October that Obion County Jail was also insufficient to house him, saying that Drummond posed a significant behavior and security risk due to violent behavior and disciplinary infractions during his latest incarceration. Judge Hayes previously said Drummond had, quote, quite the audacity to oppose being moved after his previous actions. Drummond's defense argued that transferring him to state prison would cause challenges ahead of trial. Let me see if there is a different article saying exactly what he did. Here we go. Austin Drummond, the quadruple murder suspect awaiting trial. This is when he was moved on October of 2025. Transferred from the county jail to a state prison, with officials citing his alleged problematic behavior behind bars as the reason for the move. In court Monday, Lake County Assistant District Attorney Andrew Hayes described Drummond's disruptive conduct, stating the defendant was disciplined for possession of Suboxone strips, a controlled substance that is prohibited in jail. Hayes said Drummond has also been covering his cell door with various materials, including paper and feces. So that is why. So it is on him. He did it.
Would be sufficient. But there's a whole bunch of jails that are available that were not considered at that hearing.
Does the defendant have information, specific information that would help the court make findings?
I'm not sure what the court is looking for. I mean,
What's your motion?
I understand, Judge, but the court is required to hear from the local jails what efforts did the government make to find a sufficient jail. I mean, just because he's in TOC now does not mean that he is not required, cannot be remanded to a sufficient jail.
Well, hey, hold on. Hey, real body moving. Good to see you, babe. Hey, Grateful. Good to see you too. Drummond is a menace. He is. And he is pulling some Taisha Lynn level bullshittery, although he wants a speedy trial. Like, bro, you're the one that is doing things that are delaying the speediness of your trial. And BT Dubs, it's not going to be speedy because at the end of the day, you are charged with 4 counts of murder and you are death penalty eligible. The state is seeking the death penalty. It's going to take a minute. You're gonna, so acting a straight bozo in the jail, in the prison ain't gonna help you.
Inconvenience for the jail is not something that is the standard. The standard is whether or not it's insufficient.
Well, it sounds like under your theory of this thing, the court's required to have complete.
Yes, body moving. He is still wanting to go pro se, although the judge made a ruling on that 5 days ago, and we're going to get to that. I just wanted to show you guys. I think this is important because obviously I know what the ruling is, and so I thought this would be important for everybody to watch and get caught up. They're also saying that even though Austin Drummond wants a speedy trial, they're talking about like 2027 for his trial. We'll see.
New hearing every 30 days.
That's correct.
To decide whether or not there is a local jail.
That's correct.
But you asked for that review under 41-4-121,
Yes.
right?
Yes, sir.
Okay, so that statute says, an order issued under this section shall be reviewed by the issuing court at least once every 30 days. In conducting the review, the court shall determine whether the order needs to remain in place, be terminated, or be modified to place conditions on the order. Now here's the part I'm really interested in. In evaluating whether the order needs to remain in place, the court shall consider the jail or juvenile detention facility's obligations relative to the use of restrictive housing. That's what I'm required to review.
Yes, sir.
If the order is terminated, the prisoner shall be returned to the county jail. Juvenile detention facility doesn't apply because he's not a juvenile. Shall be returned to the county jail. So what do you think that tells me I've got to do? Do you think I need to take a survey of jails throughout West Tennessee to determine whether or not there's a jail that can house?
I'm not sure there would be a survey per se for the court to do.
No, I don't think it, as you know, that's
Yes.
not my role.
Yes, sir. But the state's motion, they presented testimony that he was getting disciplinary issues, but
I would just like to point out that I like this judge already. If I were ever in the legal system, right, if I ever had to do my life over and got and decided, I want to be an attorney and then did my time as an attorney and then made it to be a judge, this is the type of judge that I would be. Snarky and sarcastic, which I appreciate because look, the jail has an obligation, not just to Drummond over there. They have an obligation to all the other inmates that are being housed in that jail. And if he is, publishing parts of the discovery, if he is covering his door in feces, if he is, getting a hold of contraband like Suboxone. I mean, we're not talking about contraband like he had an extra towel. You're allowed 4 towels and he had 5. All right. We're not talking about that. We're not talking about, minor infractions here. Okay. We're talking about being a freaking menace. All right. And having a gang affiliation. That is another issue in and of itself. Okay. And that's on your client, Mr. Attorney Man. Now, I appreciate that you want to give your client the very best defense and that, in order to do that, because that is a right afforded to him, you have to have access to him and, he has to be able to assist in a meaningful way in, his defense. I get all that. Those are all rights that are afforded to him. Okay. I'm familiar, but at the end of the day, maybe you need to tell your client that he needs to get right because he finna get left in the jail. In the prison. Okay. That's what's happening here. Let me see what that noise was. Let me see. Thank you, Lisa, for sending us sunshine. I appreciate that, babe, very much.
again, a matter of convenience is not the standard. It's whether or not the jail is sufficient. And it's a continuing duty. Do the conditions still exist today in Lake County? Do the conditions still exist today in Lyon County, Dyer County, any of the local jails, especially within this district?
Well, to that end, do you have any information that the Lake County Jail or the Lyon County Jail are better suited to house Mr. Drummond than they were when the order was initially issued?
Well, I would stipulate that Lake County would not be a permanent order. It's small. And given the issues that have come up already, I don't think that Lake County would necessarily be someplace that would be sufficient. I guess is the word I'm looking for. Lyon County testified that it was inconvenient and he was causing problems, but I don't know if those conditions still exist at Lyon County. The sheriff is here to testify, but as far as that's concerned,
And you're subpoenaing or the state's?
the state's opinion.
Okay.
Yes.
Let the record reflect that I'd like to apologize for not using my twang appropriately during the reading of that last article respective to the pronunciation of the Obion County Jail. That's my bad. I'm sorry.
Okay. He is here. Lyon County is here as well. I'm not.
Well, you know, the court order was reviewed by the Court of Criminal Appeals.
So you know,
The court order
yes,
was
yes.
reviewed by the Court of Criminal Appeals.
yes.
It was denied.
And it remains in force.
Yes, and I'm not suggesting that it was necessarily wrong at that time, but under statute, the court has to determine if those conditions still exist.
Thank you very much.
Your Honor, first of all, on the issue of the 30-day review, this is not the proper case to be reviewing that for. He was not transferred to safekeeping and TDOC for the case that we're here for today. He was transferred under docket numbers 23 CR 10945 and 24 CR 11036. And those are two separate cases that occurred while he was still incarcerated. So those are actually cases that require the review, not the case today. In addition to that, my concern with this is this motion is for him to be remanded to the local jail. The problem I see with that is the only jail that is required to hold him is the local jail, is the Lake County Jail. I don't think the court has the authority, or me or anyone else, to order another jail that is outside of this county to hold an inmate. It's not their obligation, it's not their responsibility. So if the court granted this, I think the only one that the court would order to hold him would be the Lake County Jail. And it's obvious that jail is not sufficient. The defense even agrees that jail is not sufficient. You've already heard from Lyon County and our county about their willingness to hold them. I actually had them here again today. Their testimony would basically be the same as it was in the previous hearing. So I'm happy to put them on, but I think it would be repetitive because that's what the court's already heard. So I think that is the major issue. In addition to that, Mr. Drummond has continued, as I stated previously, to have issues even while he's in Department of Corrections for the safekeeping. And we have certified documents that show the disciplinary issues that he's had since he's been in the Department of Corrections. So if there are issues there, who is the best person equipped to deal with him? There's obviously going to be more serious issues than what we do. So based on that, we think that it's appropriate for him to the motion to be denied.
When I look, I used 41.4.121 on Mr. Huffman, and I feel like I need to do it in terms of being complete. A2, subsection A2, in all cases where it is shown to the committing court, I guess that's our court.
Yes.
That the jail of the county in which the commitment should be made is insufficient for safekeeping of the prisoner, the court may order commitment of the prisoner to the nearest sufficient county jail. I think it is within the authority of the court to require another county, as counterintuitive as that may seem. That is what the legislature said. So I think I've got that, but that does not, that's a far cry from is this an appropriate case to do that. So I want to hear you approach today on the issue.
Yes. Governor, I'll call Sheriff.
Been stipulation that Lake County, right, is not sufficient to.
I'll call Sheriff Jeff Fox.
I want to hear from this witness, but also I would also like to see what his discipline record is in prison. He's being held in prison and still can't act right. What a mess.
You saw his third testimony you're about to give us the truth to help you God?
I did. Would you state your name, please? Jeff Fox. And Sheriff Fox, which county are you the sheriff for? Dyer County.
Hold on, I forgot to say good morning and hello to Coffee and Skeletons. Good to see you, babe. I mean, look, here's the thing. I get frustrated and irritated with defense attorneys, and it's real hard for me because I completely respect and understand the job that they have to do. You know what I mean? Like, You know, they took an oath, and they don't have to like their client. They don't have to agree with their client, but what they do have to do is represent their client to the best of their abilities. And that's what's happening here. And, you know, when it comes to a criminal case, the defendant is actually in the best position to aid in their defense. They're the only one really who can aid in their defense as far as what they did, you know what I mean? They're the ones that tell the attorney, hey, contact this person, contact that person, all of those things. And they got to be able to have access to their client. And I understand that. And I understand that when a person is housed in prison, the rules governing visitation and access to the client are much more strict than they are in the county jail. But at the end of the day, the reason why he's being held in prison, regardless of which case it falls under, because remember, he's got other cases pending, is the fault of the client. So I understand why you need to advocate for your client, but bro, I don't think this is going to change.
And as sheriff of our county, you also maintain a jail. Approximately how many inmates, or how many beds do you have there? So,
We have 236 total, 2 buildings.
and how many jailers do you have for your jail?
There's 23 on the payroll.
And do you have a
Hold on. Chicken Lady said, Jen, at the end of the stream, may we have your thoughts on the new GRB shenanigans? Be careful what you ask for, because yes, I am completely, fully prepared.
a pod of cells that are designed to hold maximum security prisoners?
I do.
And are you familiar with the case involving Austin Drummond?
Yes, I am.
Has he been held in your jail previously?
I believe he may have been at one point. General, I'm not sure.
Do you feel that your jail is sufficient to house Mr. Drummond?
General, we're at 103% capacity. We have 245 inmates today with a 236 capacity. You can't segregate properly once you get above 85% of your capacity, because a lot of these cells and pods may have 10 to 12 people in them. They're all not maximum or segregation pods, and most of those are full with mental health patients and other violent offenders. Plus, also I have one of the victim's stepbrothers incarcerated this time there too.
And so would it be fair to say that person, Mr. Drummond, would not be compatible in that jail?
They wouldn't be compatible at all.
So based on that information, do you think that you have the appropriate facilities to be able to house Mr. Drummond?
No, sir, I don't. I'm under a plan of action due to overcrowding at this time in the state of Tennessee, and we're building additional cells at this time, so it would not be fruitful at all for me to take a prisoner on a secondary charge or the primary charges over here in Lake County.
I'll pass this.
No questions.
Sit down, thank you, sir.
Thank you.
Free to go.
What's up?
You're on call Sheriff Jackson.
You solemnly swear to the testimony you're about to give is the truth so help you God.
And state your name, please.
Carl Jackson,
And Sheriff Jackson, which county are you sheriff for?
O'Brien County.
And in O'Brien County, how many beds do you have at your facility?
We have 159 beds.
How many people do you currently house there?
I think our ADP today is 132, I believe. I'm sorry, 137.
37. And I think you previously housed Mr. Drummond, is that correct?
Yes, sir, we did.
And do you have a facility that can hold max prisoners?
Yes, sir, we did.
And when you held Mr. Drummond, were there issues?
Yes, sir, there were.
What type of issues did you have?
Mainly manipulation issues. We had a drug issue one time. It was, in my opinion, very taxing on our staff to have to deal with him when we brought him out. A wreck, we were having to take safety precautions during that wreck. I mean, if he doesn't get his way, he acts out, maybe not violently, but in other ways, such as smearing feces on the walls. And on the window for the cell door. He also would write little notes about when this happens, you're responsible, basically.
Did you take those as threats?
I took it as him trying to manipulate the staff and basically do what he could to have his way.
Do you feel that your jail is sufficient to hold Mr. Drummond? You've already held him, so you have a better idea probably than others.
We currently, I'll just be frank, right now we're currently holding 3 inmates in our jail for murder. One is a 15-year-old or 16-year-old juvenile. Another one's one that shot a Wheatley County deputy. We're holding that one for Wheatley County, and we have one that we're actually holding for Sheriff Box right now as well. So I feel that we're doing our part for this area.
Okay. And do those people take additional staff when you have people that require more security?
They do.
And you're providing extra security now for those 3 that you're holding?
And we have to take a lot of extra precautions for the juvenile. Yes, sir, that's very taxing as well.
Will this be a burden?
Yes, sir, it'd be a burden on Obion County Jail, our staff, and quite frankly, the citizens of Obion County. I mean, I've got 6 other officers here today other than me.
Sheriff Jackson, you just testified that you deal with violent criminals.
Yes, sir.
Like you got 3 that are pretty high priority.
Yes, sir.
Did those criminals act out? They're not model citizens.
As far as right now, no, everybody is under control right now. We just took the juvenile a few days ago, so that's still in the process.
Would it be fair to say that you routinely deal with difficult prisoners?
Occasionally, yes.
And your staff's able to handle those?
Most of the time. Sometimes we have to call road deputies in to assist. This would just be an extra burden on us at this time.
And so previously you just now testified that he manipulated the staff and had drug issues.
He attempted to manipulate, yes, sir.
Was he violent with staff?
No, sir.
Did he ever try to escape?
No, sir, but he did give a plan of escape to a confidential source within the facility.
He was being segregated from all inmates, correct?
Yes, with the exception of the maximum security pod, and we did try to keep that separation, but even at that, when he used a phone, he was using somebody else's PIN number to make phone calls to get out. I mean, he continued to try to manipulate the situation.
And that's not unusual for inmates.
I don't believe we've ever had this much trouble since I've been sheriff.
You have gang members in Obion County?
We do. We have to separate them.
Do they ever pass notes and things of that nature?
Everybody's always moving kites, yes.
So that's not unusual for Mr. Drummond to do those types of things.
Some of it. I mean, I don't have people that's leaving notes around trying to manipulate staff, trying to talk about what he did before he came to jail.
So no other gang members do those types of things?
I don't have anybody trying to manipulate the staff that I know of.
Are your staff easily swayed?
Well, currently we're going through a rehire process where we've hired 6 new staff that are currently in training. So, you know, anytime you have somebody new, they have to learn the ropes and they could be easily manipulated.
But you have a system set up to screen those types of things, correct?
We try our best.
Look, he's a problem. All right? They already have people who are in the jail who are problematic. I mean, why add more to it if you don't have to? They don't want him there.
But just like any place, people get through.
I understand. Inmates can be pretty creative.
Yes, sir, they have 24/7 to figure something out.
Do any other inmates act out when they don't get their way?
Occasionally we have that some.
Mr. Drummond was not an unusual case other than the fact of what he charged with, and no writing.
Other than the manipulative notes and actions.
Sheriff Jackson, in addition to holding state inmates, county inmates, do you also hold federal inmates?
Yes, sir, we do.
And does that require you to have additional staff for that as well?
We have to segregate them separately, which also takes up room. I guess best way to describe it, if you have a B-pod, which has 22 inmates in it, that's 22 federal inmates. So we have B-pod, we have E-pod and F-pod that are all federal inmates. That limits where we can stick somebody. So if we wind up having trouble and we have to utilize D-max and we don't have anybody to put them or anywhere to put them, then that makes it even more difficult for us.
So does that also make it to a point or so that your jail is not sufficient to house Mr. Drummond?
At this point in time, I feel like we're more taxed than we were when he left.
Thank you.
Sheriff, are you required to take federal inmates?
We have a contract, or well, it's an IGA, intergovernmental agreement with U.S. Marshals, and quite frankly, without the U.S. inmates, we would be in a heck of a financial jam.
So you get paid to take the federal inmates? Right?
Yes, sir, they actually help us pay our bills.
And you also take money for state inmates as well?
Yes, sir, nowhere near the coverage, though. Thank you, Your Honor.
Your Honor, no one approved, however, the documents that I passed forward, I'd like those to be considered.
Okay, certified copies, just get them marked.
Let's say.
No proof of defense, right?
None? How do you propose this review works going forward? When you file a motion to conduct 30-day review?
Judge,
I'm not able to convene and subpoena, have witnesses brought in every 30 days to.
I understand, Judge, and I do also understand that, yes, that the being housed with TUNC on these other cases, which is sort of, it's collateral attack, if you will, because he's not being housed with TUNC on this case.
Right.
But as a consequence of those cases, he's still being housed. And again, it's a pretrial detainee, and the court's required to conduct those reviews. In those cases, this is essentially bypassing those children and getting back to the court. Of course, he's got a jury trial coming up soon.
Right.
And that, if he is convicted in that case, it may render this issue moot.
Yeah, we're really talking about a 60-day window of time, aren't we?
Yes, sir.
67 days to trial.
Yes, sir. But the court still has the statutory obligation to review every case.
All right, look, it's been reviewed.
Yeah, as far as the review goes,
Let's go.
I don't think the statute says that we have to actually come into court and have a hearing. It says the court has to review it. I don't know why that can't be done in chambers. And I think unless there is some new evidence, there's not much to review. I think that would be on the defense for them to bring in proof that, hey, we have found a jail that we think is sufficient. We're asking you to review and consider that.
I agree.
Thank you. I was looking for the transfer order, and I haven't been able to find it. Does anybody have a copy of that? Handy? The original.
I'm gonna speed this up just a little bit, y'all. We're gonna try 1.5 speed, okay?
Just a second.
Oh, let me fix it for y'all. Sorry about that. I don't want to miss anything, but I also don't, there's a lot of paper shuffling, and I'm not going to make y'all sit through paper shuffling, and I hardly ever use video from Facebook. It's not really sure, how good it is, so I'm not, trying to skip.
What I do know is originally, according to the state, the hearing on the request to transfer was conducted October 27th. So of 2025, I expect, it predates the indictment in this case, by the way. So I expect that order has been in effect since at least early November there. The threshold question is whether the order should remain in place, be terminated or modified there. So the transfer has been in place since, I think early November is a safe time. Question is, has the situation improved according to the testimony? According to the stipulation regarding the Lake County Jail, it is inadequate to hold the defendant pending trial. Excuse me. Sheriff Box is over capacity in Dare County at this time, also houses a relative of the victims. One of the victims in this case, Sheriff Jackson. The court found the conditions that existed in Obion County created a situation where it was inadequate. There's been no proof that those conditions have improved. In fact, Sheriff Jackson has indicated, if anything, things are worse at that time. I don't think the court has any authority to require Obion County to discharge or remand federal prisoners in order to make room for the defendant in this case. That is sheriff's duty and job to run the jail, not the court's job to run the jail there. Continued transfer then appears to remain necessary because there is no improvement in any close local jail.
All right, keep him there. Let's move along.
There's been no assertion by the defendant that the Department of Correction facility where he is currently housed is insufficient, except to the extent it creates a barrier for the meaningful review and preparation, review, discovery, and preparation for trial, where the court is working on that issue based on the prior hearing on the motion to modify the protective order. So it is not necessarily the Department of Correction, that does not create a insufficiency, it just creates a barrier to preparation there. The conditions under which the defendant was originally transferred were related to safety and were not considered and were not intended to be punitive. Been no indication as to whether the defendant is in restrictive housing, as that term is used in 414121. Not there. There's also no indication about whether the defendant is in solitary confinement. That's an old term there, but there's no assertion here. The court will conduct a regular review on some level in compliance with the statute there. And it doesn't seem at this time that the transfer to the Department of Correction amounted to an atypical or significant hardship, except with respect to the ability that we talked about on review. The order granting the motion to transfer was entered October 29, 2025 there. That order was subjected to review by the Court of Criminal Appeals. There are no less restrictive alternatives at this time. The access to counsel is a significant issue for the court, and the court's going to make that, going to follow up with that with respect to the motion to modify the protective order. If we're able to find a way to deal with that on an electronic basis, I think that issue will be solved, and we'll have that video. That's the only factor that really concerns the court. So at this time, the review has been completed, and the court declines to transfer the defendant back to a local jail at this point.
All right, so he's going to stay. He's going to stay in the Tennessee Department of Corrections, awaiting trial. All right, what's next, Your Honor?
Other motions?
There's probably one other motion for mental evaluation, which is taken out of those, and we've actually already entered an order.
Right.
We need to discuss it briefly. Dr. Brown, I think, from Pathways, he went up to the Department of Corrections, did Mr. Drummond, and he refused to file the court order. After that, it goes to litigation, this is in his face. But the email that Mr. Butler and I got back from Pathways that Mr. Drummond refused to.
I knew I had not seen any result of that.
All right, so if you guys are having trouble hearing, basically there is a motion for a mental health evaluation. And evidently, Mr. Drummond, I know y'all will be shocked by this, was not cooperative with the evaluation.
I might have spoke a little bit. TDOC also would not let it be recorded without a court order. Maybe more TDOC would not record under the Pathways, but he gave a review of Mr. Drummond's that.
All right, just a matter of information, I suppose. All right, Mr. Drummond, let's talk about your request to represent yourself. Go ahead. Mr. Drummond filed a motion. It was received by the court and filed April 21, 2026, seeking to terminate counsel and to represent himself in the matter. The court asked Mr. Drummond to complete the waiver questionnaire, which it appears he has done. There, he's also executed a written waiver of counsel in the matter. Mr. Drummond, I need to ask you some questions, sir. And I'm going to place you under oath to do that because I need you obligated to tell me the truth. So, you ready?
You solemnly swear that the testimony you're about to give is the truth, so help you God.
I do. Mr. Drummond, the court is required to advise you on the disadvantages and the dangers of self-representation, particularly in a case like this. And I'm going to also ask you some questions to determine whether your decision to represent yourself is being made knowingly and intelligently. You're obligated to answer my question truthfully. If you were to answer any question falsely, you can be punished for perjury. You know what perjury is, sir? Yes, sir. You've handed back the document called Waiver of Right to be Represented by Counsel. Did you complete yourself the questions there? Yes, sir. Some of the questions I'm going to ask you are going to duplicate what's in the form, but I think I want to hear you. Yeah. How old are you, sir? 29. 29? Yes, sir. You have a general equivalency diploma? Yes. Yes, sir. What grade? What was the highest grade you completed in school, either public or private, before your GED? 10th? Yes, sir. Were you able to read through the waiver documents, 8 pages? Were you able to read that and comprehend that without any problem? Yes, sir. Did you have to ask anybody what any of the words meant? Not the words, no. Okay. Dumb question. You've not been to law school? No, Your Honor. Have you ever undertaken any formal study of the law? No, Your Honor. Have you ever represented yourself in any case?
No, Your Honor.
I said you hadn't represented anybody else. Even in the Department of Correction, you didn't help someone else with their case, like a disciplinary hearing or anything.
No, Your Honor.
Have you ever been through or sat through the trial of a capital murder case?
Not capital murder case.
What trials have you sat through?
My trial for the robbery when I was 16.
As a 16-year-old, you sat through a robbery trial, your own robbery
I
trial?
was 17 at the time.
17 at the trial? Madison County?
Yes, Your Honor.
You understand that you're charged with the first-degree premeditated murder of Matthew Wilson in count 1 of the indictment, of Courtney Rose in count 2, of Adriana Williams in count 3, and of a juvenile BW in count 4 of this indictment, sir?
Yes, Your Honor.
You understand if you're found guilty of premeditated first-degree murder, the jury could sentence you to life imprisonment without the possibility of ever being released or death. You understand that?
Yes, Your Honor.
You understand you're charged with the kidnapping of the juvenile BW in count 5 of the indictment, sir?
Yes, Your Honor.
If you're found guilty of that, that's a Class A felony. You could be sentenced anywhere from 15 to 60 years at 100% service of that sentence.
Yes, Your Honor.
You understand in count 6 of the indictment, you're charged with being a convicted felon in possession of a firearm, sir?
Yes, Your Honor.
Do you also understand, you big dummy, that not only do you have to prepare for the, I don't like to use the term innocence because I think it means something but different, but whatever. Let's use the common parlance, a la Alessi. I love Alessi. Let's use the common court parlance, the guilt-innocent phase. In addition to preparing the guilt-innocent phase, you have to prepare for the potential that you will be found guilty, and therefore moves into a separate penalty phase where you will need, you don't have to, you're not required, but it would behoove you to present mitigation evidence, which usually means expert witness testimony. Are you prepared to do that?
And that felony conviction relies on the conviction, the trial you referenced a few minutes ago, your aggravated robbery conviction in Madison County, case number 14 CR 423.
Yes, Your Honor.
That's a Class B felony, being a felon in possession of a firearm, and the sentence there could be 8 years to 30 years in prison as well. You understand that?
Yes, Your Honor.
Count 7, you're charged with employing a firearm during the commission of a dangerous felon. That's count 7. In count 8, employing a firearm in the first degree premeditated murder of Matthew Wilson. That's count 7. In count 8, employing a dangerous firearm in the first degree premeditated murder of Courtney Rose. In count 9, employing a firearm in the first degree premeditated murder of Adriana Williams. And in count 10, employing a firearm.
Open your eyes whenever he says their name. Do you hear me? Open your fucking eyes. I'll leave. Open your fucking eyes, you bitch. I hate you, motherfucker. God damn you.
I'm going to need the gentleman detained. We'll take up that matter.
He's going to be detained.
All right. So obviously that is a victim's family member. I can't get mad at him. Look, I ain't going to get mad at him, but the judge is going to detain him. And I don't so let's leave it there.
And in count 10 of the indictment, employing a firearm during the first degree premeditated murder of Adriana Williams. These are Class C felonies, Mr. Drummond. Those are each punishable. The range of punishment is 3 to 15 years. In prison, there's a mandatory minimum of 6 years there. You understand that, sir?
Yes, Your Honor.
And in those counts of the indictment, those sentences will be consecutively served. That's mandatory, not the court's decision.
Yes, Your Honor.
You understand? And I don't know anything about your case. I don't know anything until it's revealed to me in the courtroom of what I can read in the indictment. But do you understand that there may be defenses that you may have to some or all of these charges which require the presentation of testimony, of documentary evidence, of other proof, or of testimony of witnesses, sir?
Yes, Your Honor.
And legal argument, that's right.
Yes, Your Honor.
If you're found guilty of one or more, no, that's not right. If you're found guilty of more than one of these offenses, the court could order that you serve all of your sentences consecutively. That is one after the other. You understand that?
Yes, Your Honor.
Attorneys in what I call a capital case, that's a case where the state seeks to impose a death penalty on the defendant if convicted. Those lawyers are specialists who have more knowledge and more experience about this specific kind of case than anyone else. Do you understand that? You understand that not even all lawyers could qualify to represent you in this case, sir. In fact, there are very few lawyers who qualify to represent you or any other defendant in this kind of case, that is a capital case. You understand that? You understand if you represent yourself, you're on your own? You understand that the court, neither the court nor anyone else can tell you how to try your case or advise you on how to try it. That is, unless the court appoints. What we call is advisory, or we call it elbow. That's kind of slang. Elbow counsel means that they synthesize you and advise you, but they do not take any part in the proceedings. You understand that? And I can't tell you how to try your case, or if you're going off the rails, I can't bring you back home. You understand? There are pretrial motions, and you've heard some of this going on this morning, and other procedures involved in the capital case. I would say, Mr. Drummond, this morning we have barely scratched the surface of pretrial motions, of defense tactics and maneuvers and strategy designed in order for you to be able to defend this case. Some of the proceedings that are going to occur may not occur in the courtroom. That is, when your lawyers ask me to appoint an investigator, a mitigation specialist, a psychiatrist, anybody, any expert in your case, those matters do not occur in the courtroom. Those matters are done by rule. Ex parte. You know what ex parte means? It means just them and me, or just you and me.
Right. It means without all parties.
Understand that? The other side does not get the ability to participate. You understand that if you have to make an ex parte request of me, that you've got to follow all of the appropriate Supreme Court rules and all of the statutes that apply to that. You understand the court cannot help you, will not help you with those matters. You understand that? Are you willing to give up your right to have an attorney draft documents for you?
You don't even know how to behave in prison, let alone jail. You think that you're capable? What a fool! What an absolute buffoon!
Which part of that, Mr. Drummond, do you think you're going to do better than a lawyer who specializes in capital cases at?
Better?
Yeah, better.
I don't know if I can do it better than the lawyer on what there's things that have to be done that have not been done.
We're going to come to that in a minute, okay? And I appreciate you bringing that up. We'll talk about that in just a moment.
Look, now we're getting to the meat and the potatoes of all of it. All right. The reason that he wants to represent himself is because there are things that he has asked his attorneys to do that they have not done. What a petulant, crybaby, toddler level temper tantrum. What an idiot.
If you do not believe you can do this better than lawyers who have anywhere from 20 to 40 years experience, I'm guessing, Mr. Ferguson. How many years you have? 26. You're talking? Okay, so 48 years combined experience. If you don't think that you can do this better than the lawyers, why would you want to try it? Why would you want to just throw away the benefit of the advice that you do and the ability to assert defenses, to advocate on your behalf? And understand that part of this is you're not getting your way so far. They're not paying attention to what you want. But I also got to tell you, when you have a lawyer representing you in a court proceeding, you're not renting the lawyer's law license. They are obligated under Supreme Court rules to exercise their independent professional judgment. And they do that so they can keep from doing things that would be potentially harmful to you, that you're not going to be able to recognize as it goes. They're going to be able to do that. If I ask Mr. Huffman and Mr. Ferguson, number one, to get your consent before they agree to something, what about that? Would that help?
I believe the damage has been done, Your Honor. There's evidence that can no longer be recovered. There's motions that have already been confirmed by the court, put in place.
What would you have done better on any of those motions?
I wouldn't agree to a gag order or a protective order. I would at least argue.
But you understand they're trying to get it done, get it modified now. You understand that? They're doing that on your behalf. And I see this morning you've duplicated that motion, but they've already filed a motion.
Look, sir, there is a gag order in place for you. It's for your protection. It protects your right to a fair trial. It is to protect potential, the potential for them not to get an unbiased jury of your peers. That's them. They put this in place to protect you. It only helps you. They're trying not to taint the jury pool so that you can get a fair trial, even though you have other cases that are pending before the same county that are going to occur before this trial. They're trying before the murder trial. They're trying to protect you. The court is. You fucking idiot.
And that's what the court takes seriously.
That's another thing, Your Honor. I wasn't made aware of these motions that were referred to. I didn't know what motion we were going to hear.
You were in court here last time.
Yes, Your Honor.
You've not received a copy of the motions?
Not all.
And that makes you want to just not have a lawyer at all, rather than get the copies of the motions and motions that are filed in the future so that you've got the benefit of that, so that you can have some input.
Get him, Your Honor.
Throwing your lawyers away better than keeping your lawyers and trying to develop a better, more open, more communicating relationship?
I just don't believe there's, I believe the trust isn't there, Your Honor.
So wait a minute now. Back the milk truck up, homeboy. You don't like these lawyers. This is how you know that you're an idiot, because you went from one extreme to the other, right? No in between for you. This is so telling of your personality and exactly how you wound up where you're sitting at right now. Right now. You could have requested that your attorneys file a motion to withdraw. Even though that's not a guarantee that it would be granted, because they have to, in order to do that, they would have to get other death penalty qualified attorneys, and there's very few of those. But you didn't try anything anywhere in the middle. And now you're just wasting time and resources. You're indigent as fuck. We all know it. Right? So everybody else is paying for this crap. Jesus fuck.
Have you read the rules that deal with the criteria for requesting funds for expert services? Do you know what a mitigation specialist is?
Yes, Your Honor. I wouldn't be presenting litigation. That's in this case I was convicted.
What about a crime scene expert? You got access to a crime scene expert?
I will be looking to.
I don't think so, Kelly, but I'll look it up just to be
How
sure.
are you going to accomplish for independent forensic testing? How's that going to happen on your own?
Well, I believe my investigator is getting into part of that.
You understand, if you don't meet all the criteria, and I can't advise you about it, that you're going to be denied.
Yes, Your Honor.
You're going to be denied. You understand the logistics and the communications that are going to be required to retain and consult with an expert?
Yes, Your Honor.
Are you able to follow the evidentiary rules for presenting expert testimony and opinions?
Yes, Your Honor.
Well, you told me you hadn't studied law. How about the rules of evidence? Have you had a look at those recently?
I haven't studied the rules of criminal procedure.
Do you feel like your knowledge of those rules is superior to 48 years worth of legal experience?
Absolutely.
So again, you don't think you're going to do this better than they would?
I don't doubt their ability to be lawyers at all.
I don't doubt their ability. I just don't like them. We can't be friends. The friendship door is closed. What a idiot. I just wanted to, I think I know the answer, but I don't like to speak it out. You know me. I like to look it up because I'm not an attorney. But the answer is no. You cannot. You were your own counsel.
But you still want to give up the right to have that help, to get those experts funded and working for you. And you want to change criminal investigators, I understand as well. Yes, sir. Am I right? You want to give up the right to have them do that part of this case for you?
The ones who are currently employed, yes, Your Honor.
Employed, bruh. Like you got staff. I need a video. Let's go to our correspondent, Mac the cat, see how Mac feels about all of this, shall we? Mac, what say you? I know, Mac. Can you believe this bullshit? Also,
I am so tired of you.
and finally,
No, you shut up! Don't talk to me! Don't talk to me, criminal!
all right, are we all better now? I feel better. Let's go.
Are you able to hire counsel?
No, I'm indigent as fuck. Which is not a judgment. I'm not being judgy about that. Technically, if I got into some shit, I'd be indigent as fuck too.
Do you understand the types of questions that are going to be appropriate and inappropriate to put in a potential jury questionnaire?
Loosely, Your Honor, but I'll continue to study the law library. I have better knowledge of that.
You have access to the law library where you are now?
Yes, Your Honor, that's the only thing I'm able to do on my tablet.
You understand?
Look here, bro. You can't even act right. Do you understand where you're being housed right now? You in the big house, bro. You in jail. You're not even in jail. You are in prison, which with much stricter rules. Okay? And you'd already act a fool. You act up. You don't act right. You misbehave. You do all the things. Do you know the first thing that's going to happen in the form of discipline, right, is you're going to be confined to your cell. You're going to be on extra punishment, additional punishment. Idiot. God.
You're able to do that on your tablet?
Yes, Your Honor.
You understand I can't advise you about the rules of criminal procedure, the rules of evidence, or the Supreme Court rules on obtaining expert funding.
Yes, Your Honor.
Can't advise you on the rules of evidence. You understand that as well, sir?
Yes, Your Honor.
So tell me what you think happens if the jury were to find you guilty of first-degree premeditated murder. What happens next?
I'll be satisfied with that.
See? You don't even know.
Understand that there's a second trial.
You don't even understand. Let me be quiet. Let me get myself together. I'm feeling yelly and out of control, and that's not professional. The couth has left the building. Let me get myself back right.
Yes, Your Honor, I will waive that and allow you to sentence me.
You would waive the right to present evidence to a jury in the hopes.
Hold on a minute. No, I done slowed him down, Coffee and Skeleton. We're at 1.25. So yes, he would be talking even slower. But I wanted, sometimes because of that, like hum, the ambient noise in the background, it makes it even more difficult to hear and understand. So I slowed him down just a touch. All right, here we go.
Saving your life.
Yes, Your Honor.
How is that better than than trying the case? How does that put you in a better position?
Well,
Why is waiving your right better than exercising your right to have the jury make that decision?
I believe that's my right to make that.
Why is that in your better interest? I'm curious.
If I was to be found guilty, Your Honor, the conditions that trial are much better than they would be with life in prison.
But you understand what a death sentence means.
Yes, Your Honor.
You understand you have the right to testify during both the trial and the sentencing hearing afterwards.
Yes, Your Honor.
You understand that you may not be able to just take the witness stand and just start talking.
I was made aware of that today, Your Honor, yes.
Does that impact your decision at all?
No, Your Honor.
The state has filed a notice indicating, Mr. Drummond, that they're going to present evidence of these aggravating factors. A, that you were previously convicted of one or more felonies whose statutory elements involve the use of violence against a person. I suppose that would be the aggravated robbery, at least at this point. B, that you committed the murder of more than 3 persons within a single episode or at different times within 48 months. C, that the murder committed was done so in the course of an act of terrorism. I'm not saying whether it is right or not right. I'm just telling you what the state intends to prove. Fourth, that the murders may have been committed at random, and the reasons for the killings are not obviously or easily understood. You understand that part?
I understand that. I'm not saying that.
But you're telling me you would not want to participate in the sentencing phase of the trial at all. You would want to waive that.
Yes, I hope so.
Whether that's permissible or not permissible, you want to waive it because you believe that you're right.
Giving the sense is all concerned about.
You understand if you represent yourself, I can't guarantee you have access to a law library. That's not a guarantee the court can make.
I was unaware of that. I am now aware of that.
Once the trial is scheduled, Mr. Drummond, unless I determine there's a need to continue the trial, you'll be expected to proceed when the trial begins. You understand that?
Yes, sir.
You understand how to get a subpoena if you want a witness to appear at a hearing or a trial?
I understand. The court would.
You understand that'll be your responsibility, nobody else's, for yourself.
Yes, sir.
If you represent yourself, you understand you'll have to abide by the court's rules regarding courtroom behavior, and that you may only address me during the proceedings unless you are making an opening statement or a closing argument to the jury.
Yes, sir.
You understand that during a trial or any other proceeding, you may not freely communicate with persons in the courtroom.
Yes, sir.
Okay, you don't have access to them. If you represent yourself, you will not be able to claim in an appeal that your advisory counsel was ineffective. You understand? And you cannot claim that you were ineffective at representing yourself. In other words, those claims that we call post-conviction claims for ineffective assistance of counsel are gone.
Yes, sir.
You understand that's a significant deal.
Yes, sir.
Do you understand that almost 100% of capital cases wind up in a post-conviction proceeding involving a complaint or an assertion that counsel was ineffective?
I was not aware of that.
Almost every one of them end up there. And you understand you're giving that up if you represent yourself.
Yes, sir.
Man, thought about that, have you?
I'm not thinking about it too.
Another dumb question. You understand you have the right, absolute right to be represented by law.
Yes, sir.
You understand at the trial you have the absolute right to testify, but you also do, you understand that nobody can force you to testify, whether you have 10 lawyers or 0 lawyers.
Yes, sir.
That right to have a lawyer to represent you is on every day of court, every stage of your case, every day of trial, every appeal, every post-conviction proceeding that you're otherwise going to waive if you give this up. You have the right to have a lawyer represent you. If you get in a bind during trial, you don't know how to object, how to fix something that's going badly, you know you're going to be held to the same standards as a lawyer, as your 28 years of experience. The court cannot provide special or preferential treatment to you because you represent yourself. Understand?
Yes, sir.
If you introduce evidence in a way that does not comply with the rules, the court is not going to permit. You understand that? There's no, I'm doing this by myself, I'm not real sure how to do it. You understand that?
Yes, sir.
That's not an option in this case.
Your Honor, just get to the part where you ask him the question you really want to ask him. Just go full Mr. Hand on him. What are you people on dope? That's what you really want to ask him. You really want to ask him, are you high? Are you an idiot? What are you, an idiot sandwich? What's going on here? What I can't understand this thinking. As many trials as I have watched, criminal and civil, admittedly, civil trials are more rare than criminal trials, so I don't have as much experience there. Can y'all imagine if I got into a traffic ticket? Let's just go there. A traffic ticket, okay? A moving violation. Do y'all think that there is any way that there's any set of circumstances that would cause me to lose my mind enough to sashay my big ass into that courtroom and try to defend myself. Of course not. This is, ugh.
Mr. Drummond, you absolutely would be better served by being defended by a trained lawyer who qualifies to assist you in this kind of case than if you're going to represent yourself. I think it's unwise of you to try to represent yourself.
I think you're a total idiot for trying to represent yourself. I agree. This is what I suspect is going on. Okay. I think that he is a big crybaby and is mad and pissed at him at the wrong people. He should be pissed at himself because the reason that he is in the Department of Corrections versus the county jail is due to his own actions and his own behavior, right? And I think that this is some level of manipulation and ploy to get let out of his cell and have more freedoms and unfettered access. That's all I think this is. This is just a BS manipulation.
Although you are looking at the law or familiar with the law from sitting in your own trial as a juvenile, I just don't think you've got the experience, the wherewithal, the ability, the access to the resources that you need in order to waive your right to counsel. My little script says, I strongly urge you, I beg you not to do this. It is not in your interest. It is not going to end well. Do you know how many people who represent themselves are convicted? Have you taken any medication today? Do you take any medication? Are you under the influence of any substance at all today, sir? No. Is there anything affecting your decision to want to represent yourself other than what you have told me in your motion and what you've told me while we've been talking today?
Your Honor, he has 3 working and functioning brain cells, and currently they're all arguing.
So I look at your motion, and you give me 10 reasons. I want to go through them. The first ground or reason you gave me was that during the preliminary proceedings, and I assume you mean the preliminary hearing, right? You asked for the 14-day rule not to be waived, but Mr. Huffman disregarded that and waived it anyway, right? And that didn't cost you anything, right?
It cost a month. The indictment was a month later.
I'll tell you, the grand jury in Lake County didn't meet till November. They don't meet in October. They don't meet in September. They don't meet in August.
Now, see, if you had any type of legal experience, if you were 1/8 of as smart as you thought you were, you'd know when the grand jury meets. That's part of the deal. But you didn't know that, you big dummy.
Secondly, you say during the preliminary hearing that Ron Huffman failed to object to hearsay. You told me you didn't read the rule of criminal procedure. You didn't read the rule that says hearsay is permissible in preliminary hearing. You also don't understand the strategy involved by an experienced lawyer, understanding the case and knowing that every available piece of information that he can get committed to the record, he or she wants in that record so that you know exactly what you are facing. Understand that? That is a matter that experience in the law, experience in trying cases, experience in representing defendants who are charged with crime brings.
Kate can create. No, babe, there is no chance that it will on the when it's uploaded to YouTube, but currently it does not. And I think of him every single time. You need a Fred Sanford, you big dummy overlay. And I actually think it's Aunt Esther who says it as well. You big dummy. It's my favorite. I miss Sanford and Son. Here we go.
And that's the experience that you had the benefit of that you now complain about, not understanding that that was ultimately something that was being done to help you. And I know you didn't understand. I'm not lecturing you because you didn't understand. But I'm telling you, that's not a reason to fire your lawyer now, that you understand the strategy involved there.
Your Honor, I just want to record, I don't believe for a second he's incapable. I think he's a great lawyer.
But I'm looking at the grounds for your motion. That is your complaint, not anybody else's. I understand you think he's a great lawyer, but you complained about that, not understanding that he was being a great lawyer at that moment. And he didn't ask any questions, you say. Did not ask questions requested by you concerning motive. You understand motive is not an element of the crime that you're charged with. Motive, not an element. Not a defense, not an element. Now, it may be self-defense. That's not a matter for today, and it wasn't a matter for the preliminary hearing. And you say in here they agreed to a gag order without your consent. I understand that part. I got you on that. They agreed to a protective order without your consent. I don't think he was given an option in that protective order. I don't think he was given an option to consent or not consent. And frankly, wasn't given an option to consent or not consent to the gag order. Because it wasn't anything that he had been involved in that caused the issuance of those two orders. I don't think this court issued the gag order. I think that was done in general session. Still applicable. In August, you wanted phone records to be subpoenaed. That would be after your preliminary hearing, before the preliminary hearing. You wanted phone records at the preliminary hearing.
I want to leave that these needs to be for the next, I know it takes time to get through, so, but I know that at the time to go away, so.
You say in November 2025, you gave him valuable information to pass on to investigators. That's after your preliminary hearing.
That was at the arraignment.
At the arraignment, thank you. Which was
November 17th.
November 17th. Brian Huffman told you he would address issues with the court on March 24. Did not address those issues. Your lawyers repeatedly pushed court dates off to later dates against the wishes of the defendant. I think we were set before, and I had a problem. One of them is my fault. Okay, one of them is my fault. The other thing is that I can't impress on you enough the fact that this kind of case moves at a snail's pace. It is not like your other cases that you have.
It's
vastly.
It's not going to be quick. You don't want it to be quick. You want them to take their time. You want them to investigate everything.
It takes longer to get prepared. You mentioned a minute ago phone records take a long time, and that is such a minuscule part of the potential proof, potential defenses, potential strategy that takes literally years to develop there, to maximize the best outcome for you. All of that. So I don't know if it's a problem, a lawyer problem, or if it's an expectation problem on your part. But the lawyer can't fix your expectations, and the lawyers cannot speed me up.
Yeah, your expectations are ridiculous. Okay, which tells me that while you are clearly a career criminal, okay, you ain't picked up nothing. You have learned nothing. In fact, your knowledge on the law could fill a thimble. You idiot. What a big fat waste of time. Oh, and BT dubs, Mr. Drummond. You're upset at the pace at which this trial is going. Do you realize that this now slows the process even more? Do you understand that you representing yourself, just filing the motion to represent yourself slows things up, but also if it were to be granted, it actually also slows things up because you are currently being held pending trial, which makes access more difficult. You can't get to stuff because you ain't on the outside, you big dummy.
Mr. Drummond, is there anything else you need to tell me? Has anybody forced you or threatened you or tried to coerce you into waiving your right to attorney? Is your decision to waive your right to counsel entirely voluntary on your part?
Yes, sir.
Ms. Ferguson, I put you on the spot. And if you don't have anything, that's fine, but do you have concerns about Mr. Drummond representing himself, sir?
On application, there are many attorneys, not being able to capitalize. They specialize training, rarely CLEs. We took a number of first-degree murder cases that we handled, that we handled a lot of Rule 13. It's not going to understand Rule 13. You'll never go to Rule 13 without directly, it doesn't understand the distance rule under Rule 13. We have trouble finding forensic pathologists. He's got limited access to a phone. He'll never get a forensic pathologist. Again, he's being housed and he'll have the same problems, same conditions. He now knows what the aggravating circumstances are, but he's not expressed the fact that he even knows the impact of his pre-trial. He also doesn't understand that he can mitigate his prior convictions. So, but again, he's already said he's waiving his guilt in his life-death trial. So then if he tries filing the next court case and the court reasonable is necessary, he's not going to use it. So that's,
All right.
I think there's a real problem.
I think we're good. I think we all get it, right? We understand that he is a buffoon. So now let's get to what we want to get to, which is the decision. All right. So here we go. All right. This article was written May 26th, 2026 at 3:51 p.m. Central Daylight Savings Time. It comes from Action News 5. Lake County, Tennessee. A Lake County judge has denied Austin Drummond's motion to waive his right to an attorney and represent himself in his quadruple murder case. Judge Mark Hayes cited, quote, heightened procedural protections in the high-profile case. Obviously, he's pleaded not guilty. Prosecutors intend to seek the death penalty, and Judge Hayes says Drummond is not fit to represent himself because he has no legal experience and has not undergone a mental evaluation in connection with this case. Drummond previously said in court that he filed the handwritten motion himself because he disagrees with decisions made by his current counsel, but Judge Hayes ruled that Drummond's court-appointed attorney, Brian Huffman, who was sufficient to defend him. Judge Hayes also described Drummond's motion as a thinly veiled attempt at manipulation. Quote, the complaints about his attorneys do not reflect a genuine desire to invoke the right to self-representation, but rather an uninformed understanding of the proceedings, which has led to his frustration and his retaliation in the form of the instant motion, the ruling reads. So there you have it. The judge said, no dice. Okay? Now, at the request of my friend Chicken Lady, we will be moving to the... Wait, I lied. Let me stop you right there. I wanted I went and looked at an update because I frequently do it, and I am always reminded to do it usually during court proceedings. Now, you know, we have been waiting for 77 years for the trial of Billy Wagner in Pike County. Here are the latest updates. George Billy Wagner III, the final suspect in the 2016 Pike County massacre, is currently scheduled for trial as early as October. His defense team is appealing an appellate court ruling that reinstated the death penalty, and they are also seeking to move the trial out of Pike County to ensure an unbiased jury. Here are the latest details regarding his ongoing case, death penalty dispute. An appeals court reversed a previous judge's decision to remove the death penalty, making it a potential sentence once again. See, Judge Hine, already you've had things reversed. I would quit while I was ahead if I were you. Wagner's defense team is taking this reinstatement appeal to the Ohio Supreme Court, citing state-level execution delays. So basically, they're arguing that that the death sentence is something that takes for a long time to impose. All right, trial date and venue. The trial was delayed from its original May 2024 and January 2026 windows. It could begin by October if the Ohio Supreme Court decides or declines to hear the appeal. A visiting judge, Judge Hine, who we don't like, has granted the defense's request to move the trial out of Pike County, but an exact location has yet to be finalized. So there you have it. Now, we shall be moving on to the latest in Gypsy Rose Blanchard's shenanigans. Okay? Let me close all these other 50, 11, billion tabs that I currently have open. Let me share my screen with you, and we will talk about it after I show you this video. Are you ready? Here we are. Now, I want you to keep in mind while you're watching this that this video has been quote unquote leaked. However, note how the video itself starts out with Gypsy Rose turning on the camera that she has clearly already set up, meaning that it's more than likely it's her device that this video was recorded on. So, if by leaked you meant that you sent it to somebody with the hope or instructions, allegedly, maybe, possibly, to go ahead and send this to somebody you knew would put it out, if that's what you mean by leaked, then yeah, I agree. It was leaked. Here we go.
This is all that I've ever been to you. This is how I feel about you. Lies! All it is lies! Lies, lies, lies! Ugh! Fucking soulmates, the hell you are! The hell you are! Lies! All of it! All of it! All of it! Nothing but fucking lies! Lies, manipulation. Fuck you.
Okay, first of all, Gypsy, okay, you clearly set this up, right? You clearly videotaped it. Jesus, Jen, get out of 1982. You clearly recorded this on your device for what reason, right? Because obviously you're wanting to put on a show. This is complete total histrionics. In the middle there, can't even work a dadgum pair of scissors trying to cut this up. I mean, look, lady, shouldn't you plan this better? This is not going the way that you think it's going to go. Nobody feels sorry for you. Nobody feels badly for you. This is utter bullshittery and redonkulousness. Look at you.
Go back to your bimbo blonde whore.
Oh, sick burn, bro. You mean you mean like when you tried to bleach your hair blonde, like that? Didn't you want to be a blonde bimbo? Which, by the way, is offensive on every level. Hair color clearly does not determine intelligence level. Okay.
Fuck you.
Fuck you. I'm sorry. This is the other then it just repeats. Still her again. Gypsy. Look, for those of you guys who aren't familiar, hold on a second. Basically, Gypsy, this happened back in like September, I think. last year. But whatever. Look, new allegations have surfaced. There's a video allegedly. Now, I've not seen this video. Ken hasn't seen this video, although he says he wants to see this video, where there's an X above the bed, on the headboard on his side of the bed. Okay. And a lot of people are stating that based on the description of the contents of that video, it's very reminiscent of the video of the Gypsy made for Nicholas, over Dee Dee's bed, where she pretends to stab at the bed, right? Okay. They're saying that, it's reminiscent of that. This is what I'm saying, Chicken Lady. Chicken Lady said, like, if I'm setting the camera up, maybe you could have made it to where you could actually rip it. Right. This was your whole, you set this up. You decided to record it. This is your demonstration about how you feel. The lies. Fuck you. Shut up, Gypsy. Okay, you couldn't go through the extra, there's no effort put into this at all. This is actually, in my estimation, a prime example of poor work ethic. Like, you don't take any pride in what you're about to do. Couldn't you have made sure, I don't know, that the scissors were sharp enough? Couldn't you have done that? Couldn't you have done that? Now look, you think that you have some sort of standing to be angry at Ken. Y'all broke up. Okay? It's not like he was hooking up with chicks while you were locked up and y'all were together. Bro, you married a whole other dude and then went on a reality show with him and cheated on him with Ken. Get bent. You think you have some ground to stand on to get mad about some exes he had? This is scary. She's cutting up some blanket, I think, that says something. I think it's Gypsy. It says Gypsy and Ken. Okay? I've been with my husband for 31 years. We have no blankets with our names on them. Come on, Gypsy. Give me a freaking break. Kick rocks. So ridiculous. You and your lame ass attempts. You're just one of those people that any attention is good attention, right? And this is why I say constantly, let me lower my volume. I'm very yelly. Gypsy Rose gets on my freaking nerves because she's so ridiculous. And she's a lying liar face who tells lies. She's always trying to do something to get sympathy, okay? And I just have no patience for it. Oh, it says soulmates on it. Oh, Jesus, fuck. That's even lamer. Hold on. Did I just cough in your ear? Or did I forget to unmute or thought I unmuted when I did? Please tell me I didn't cough in your ear. I'm so sorry. All right. Bottom line is here, this is why you will remain infamous and never attain the fame that you're so desperately seeking. Because you have no talent. Okay? Yes, it is true that your normal speaking voice is like 5 octaves below only dogs can hear. And when you get yelly, it turns to like 1. Okay? But that's not an actual talent. Okay? It's not a talent. That's nothing. You don't have a skill. All right? You got lucky is what happened to you. You got lucky in your case. And you got a sweetheart plea deal based on that luck. For whatever reason. That's what happened. Okay? It isn't because you're actually a victim of anything. If anything, you're a victim of your own yourself. You keep doing things and then it's like you're unaware or you don't care I suspect that you don't care that any attention is good attention. So you keep on doing these outlandish, ridiculous, cringy AF behaviors because you know that you don't possess any skill or quality that makes you that you have longevity in social media beyond this bullshit. You don't. I know it. You know it. We all know it. Okay. And yeah, people are going to always watch the train wreck. They're always going to. It's human nature. People will watch the train wreck, but eventually there'll be another train wreck to watch. So, yeah, this part. Right before this got leaked, says Chicken Lady, she was responding to the other allegation and said, quote, "Why would I film myself doing something like that and send it?" Like 5 minutes before this video was released. Yeah, exactly. She's ridiculous. What was the purpose of that anyway? Oh, I don't know. I don't know if this is her auditioned. This is going to be part of her audition reel. I don't know. It's ridiculous. It's stupid. It's stupid. And honestly, tells me that she's learned nothing beneficial. She's learned nothing good from her time in prison. She's not reformed in any way, shape, or form. She sees that the limelight is starting to dwindle. The spotlight is dwindling. People will look at the dumpster fire, but hold on a sec. As far as any type of longevity on social media, being an influencer, who the fuck wants to be influenced by that? Can't even work scissors right, bro. Who cares? Like, if you don't, like, she doesn't have longevity. Not at this point, anyway. And that's me saying that as I don't like this term, but this is what YouTube calls us, a content creator. I don't have longevity. I'm not guaranteed anything. I have to continue to work at it every single day. And there may come a day, I hope it's not anytime soon, but there may come a day when people are like, look, we're over the Bendy brand. We're tired of it. We don't want to hear your yelly ass outbursts during trials. Your roasts that were one time funny, now we don't find funny. That might happen. Nobody's guaranteed anything in this life. And the sooner you figure that out, Gypsy Rose, the better off you'll be, you big dummy. Anyway, that's really all I have for you guys today. So with that being said, I'm going to let you guys go. I will see you all tomorrow morning. I am going to continue the coverage of the Carly Gregg trial. We'll be on day 3. Okay. Remember she has filed she's appealed her conviction. She's in her direct appeal, she included an ineffective assistance of counsel claim, which is something that's kind of rare. It's very rare. It's not even it's just in general, an ineffective assistance of counsel claim is very difficult and very rarely successful. And it's even less successful during a direct appeal process. So I'm very curious. It's usually reserved for post-conviction relief appeals. But at the end of the day, she has filed one. So now it's got me curious. And I think we should go over and continue to go over that case. There are some trials coming up in June that, of course, I want to stream and will stream. But for now, this is what we're doing. And so I hope to see all of you guys on Monday morning, or at least on the replay. I know not everybody can. There goes Mac. I know not everybody can watch during the day, and that's cool. I appreciate that. So I get it. But anyway, I hope you guys have a great rest of your Sunday. Please, if you don't mind, give your girl a thumbs up, thumbs down, whichever you feel I deserve. I leave it to your discretion on the stream. And hey, if you missed a part of it and you want to come back later, don't forget to hype the video. I would appreciate it very, very much. All right. So I will see you all tomorrow. Have a great rest of your Sunday. Bye.